The time is 1:30 according to the phone in front of me, and the date is Monday, July the 14th, 2014. This is a duly posted meeting of the Texas Appraiser Licensing and Certification Board. This is a special called meeting for this organization to address a limited agenda today. The first item on our agenda is the call to order and the pledges of allegiance. I've asked one of our newest members, Mr. Barba, to lead us in those pledges. If you'll join me.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
The next item on our agenda is roll call.
Chair Jamie Wickwood.
Present.
Roy Farnham.
Present.
Mark McEnroe.
Present.
Lisa Garvin.
Present.
Walker Beard.
Here.
Brian Patton.
Present.
Patrick Carlson. Clayton Black. Jesse Clark.
Present.
We do appear to have two absences. We have heard from two of those members. Mr. Carlson has an impending birth in his family of a coming child and had warned us that he might not be able to travel far. And Mr. Black, I believe, had a pre-scheduled travel arrangement. Remember, this is a special called meeting, and so our board didn't have as much opportunity to plan for our attendance here today. So I would ask for motion to excuse the absences of those two individuals.
So moved, Madam Chair.
Second.
Motion and second. Any discussion? All in favor?
Aye.
Aye.
Anyone opposed? Next item on our agenda is comments from members of the public regarding non-agenda items, so anything that's not already addressed on our agenda. The process is that we have a form in the back that you must fill out and turn in either at the dais or to a staff member. We'd ask that you limit those comments to 3 minutes. Is there anyone in the public that would like to address the board on a non-agenda item? Seeing none, we'll move to agenda item number 4, discussion and possible action regarding public comments received from Don Griffin at the February 2014 board meeting. I'd like to open this agenda item, and I think the best way to open it, because it is one of the primary reasons I've assembled this special called meeting, I think the best way to open it is simply to remind the board of the request from Mr. Griffin on February the 14th, so I've asked them to queue up our video minutes for a very short period of time of his specific request. Tony, do you have those available? We can see it, but we can't hear it. And I've actually got it audio clipped on my phone, if that's necessary.
Want to put the microphone up?
Put the microphone.
Start it over. Wireless.
No worries. You're way ahead of me. I couldn't figure out how to clip the video, so I'm pleased to have any assistance I can get. And so I'd ask you to continue, keeping in mind the limitations we placed on you.
Chair Wycliffe, thank you. My purpose today is solely to ask the board to direct me in a manner where I can speak.
You know, Tony, let's do this. I think I've got it on my audio clip. Let me see if I can just...
Testimony and whatever the board feels is appropriate.
I'm not going to try and synchronize. I'm not sure the picture's important unless it is to you all. It's the words that I was interested in.
Don, where's your speaker? One more. That's all the way up. That's wired into the system. So it's not out. It's not coming out of a speaker on the computer.
Try it one more time. If that doesn't work, I'll play my audio clip.
The reason being is that in light of, from my perspective on behalf of my client, information that, thank you.
Ask you to continue, keeping in mind the limitations we've placed on you.
Chairman Wycliffe, thank you. My purpose today is solely to ask the board to direct me in a manner where I can communicate information, that information being documents, deposition testimony, and whatever the board feels is appropriate, directly to the board without having that information filtered through staff. The reason being is that in light of, from my perspective on behalf of my client, information that we have obtained in depositions and from documents raises concerns about the conduct of TALCB staff. I am not, to be crystal clear to this board, asking the board to exclude staff or a staff representative from my communications with the board. In fact, quite frankly, I would welcome Mr. Oldmixon to sit in and be an active part of what I hope is an open, transparent exchange of information that I want to provide to the board regarding staff conduct. What I am asking the board not to make me do is to filter all the information and documents and sworn testimony I would like to provide to the board, again regarding staff conduct. I don't want you to make me filter that through staff, because I believe that presents a conflict of interest with staff when you make me filter it through staff to get it to you. My hope and my only request is that after you consider this, that someone contact me and tell me this is how the board prefers that I communicate, and the manner I communicate the information regarding staff conduct I would like to provide. I'm happy to stand here and answer any questions you have, understanding I've got limitations.
That's good, Tony.
And I've told you I'm not going to get into the subject.
So I know that was a bit difficult to hear, so I have some of those points actually called out in my summary. And so I want to, the reason I thought it was important to replay it is I wanted to be sure there was a point of reference for the conversation that we're about to have. So the couple of things I would remind you that Mr. Griffin asked this board, standing in front of us, direct me where I can communicate information directly to the board without having that information filtered through staff. He specifically requests that he has information obtained that raises concerns about the conduct of TALCB staff. And he asks us again not to make him filter it through staff, as he believes it's a conflict of interest. I think it's important that the board and the public understand that February was a long time ago, and that several attempts to honor the request by Mr. Griffin have been attempted by various board members. We've gone through several iterations of what might work in order to accommodate the request, and I'm not sure the entire board is familiar with those steps. I thought it was important that we all get on the same page. So I felt like I needed to tell you my role. I volunteered to act as a liaison between staff and this board because, in fact, I will not be voting on this disciplinary issue because there has been a lot of sideline conversation about the issue. I still don't know the facts to the complaint, but I know a lot of pieces. So it seemed to me a reasonable position to take. In floating that idea, some of the executive committee and some other board members weren't as comfortable with me being the only ears, so there was a conversation about having the executive committee be the liaison and have 3 sets of ears, always keeping in mind the issue is if this board hears specifics about a complaint, they are the final authority on voting on a complaint, and our goal is to keep a big percentage of the board available, or all of the board in a perfect scenario, available to actually act on this complaint if and when it rises to that occasion. So, on April the 29th, an executive committee meeting was held via teleconference. At that time, there was some feeling that there was support for myself being the liaison. That particular teleconference was attended by our AOG rep, who indicated to us she didn't think that was a good idea. We've then asked for additional updates provided by the commissioner, which he has been giving you regularly via email, and I believe one of them came from General Counsel as well. I believe Kristen forwarded that particular update. And there have been some one-on-one meetings with the commissioner of various board members asking some questions. But something as serious as this allegation, I believe the board needs to be uniformly informed. So, keeping in mind, I think you need to be careful about asking about specifics on the complaint. I wanted the floor open for questions to the commissioner about the process, and I suppose the easiest way to lead in is simply to ask, and I believe it's been provided to the board, but for a reminder, when did you first become aware of the allegations that Mr. Griffin expressed to us in February 2014, Commissioner?
Are we on? Oh, there we go. Okay. Madam Chair, thank you. I have provided a written timeline report to all of the board members on just, I tried to be very careful to limit it to just the facts underlying the board's involvement in the litigation, the condemnation litigation that was the matter that gave rise to Mr. Griffin's comments. And so I first became aware that, in fact, the board, well, I was notified, I believe it was November the 12th, which was the date that Mr. Ray was served with a subpoena to be deposed by Vincent and Elkins in the underlying condemnation litigation. And the reason for that was that the county had named, in the underlying litigation, had named Mr. Ray as a potential witness in that litigation. And so that's when I first became aware of that. And I didn't know if you wanted me to lay out any more relevant facts or just answer questions.
I'd say answering questions is probably appropriate unless the board would like you to. It's almost as if you would need to read what was in front of you. I'm assuming that you've given us what you believe are the relevant facts to date.
Correct.
I suppose the biggest concern or issue is exactly what I expressed in opening this agenda item. And again, I think it's important that the board discuss it, or at least, let me be clear, this is not a unilateral decision. My phone has been ringing off the wall by board members saying, what are you doing and when? That's the reason we're in a special called meeting, because there was abundance of criticism about this board being non-responsive to a public request about issues associated with staff actions. And so again, being careful about the confines that we're in, I wanted to provide the opportunity that you all had expressed to me on numerous occasions that you felt you were entitled to. So I suppose the biggest issue is why it's taken this long for us to get to this stage, and then if you all do have questions, concerns, want to have a conversation about it, that's why we're here.
Madam Chair, so we are trying to determine how to receive information from the Vincent Elkins attorney, and you've made the decision it is coming through you. You are the liaison. Is that where we are in the decision tree? And
Mr. Beard, I think that's the best solution, is that they're, in order to meet the request, but that has met with an abundance of, or what appears to be an abundance of, as best I can call it, stonewalling from either legal counsel or at a staff level. In other words, mostly what we continue to hear is there's no need for us to receive any additional information.
okay, so we're trying to determine how to get the information. At this point, we're still trying to get the information from the law firm wants to give us the information. They haven't given us any information, or we haven't requested that we open the spigot and say, pour it on in. Is that right or wrong? Or
The board has not received any. I understand there's been some exchange. The information that the board has received is what you've received from your commissioner, and I believe he's given you what he has. That's not the issue. The issue is a member of the public stood before this board and said, you have a problem inside your organization. And so I guess the first question is, do we want to hear that? And then secondly, I mean, do we think it's our responsibility or job to at least identify if there's a problem? Not because, again, I think we understand who has the authority to fix a problem, with the exception of the commissioner, is my understanding. We don't have any oversight of staff directly, but we do have the opportunity to visit with the commissioner about what's going on inside the organization. So question number one is it our job? Do you want to hear it? And then question number two is, if it's our job and we want to hear it, how do we accomplish that? Because we've not yet come close to meeting the request that was made at the microphone of the public, which was, please provide me some avenue to speak to you, not fully filtering everything 100% through staff. Everything that we've received to date about concern has been filtered through staff.
okay.
And yes, sir, Commissioner.
Okay. So I'm assuming when you say staff, that includes me?
Well,
So,
yes.
okay, great. I just want to make sure. I do have a statutory responsibility to manage the staff that the board funds, and so in following on the directive, the answer to the video question was that the staff, the board directed Mr. Griffin to communicate with the board's general counsel, and then the general counsel informed Mr. Griffin that if there were issues about staff behavior, that in fact those should come to me, and then I will investigate those. So while I manage the staff, it's not a day-to-day. It's on behalf of the board, a kind of management of the staff. A bunch of the day-to-day stuff is, of course, delegated to the respective division directors. And so making sure that, since I wasn't involved, if you will, with any of the staff, quote, behavior or conduct, that I would be, it would be appropriate, that was my judgment, appropriate for me to conduct an independent investigation of all of those allegations, and then determine what the outcome of that investigation would be. Both the determine what the facts are, and then under our personnel policies determine if any disciplinary action should be taken against any member of the staff, or whether there were other actions that should be taken. So let me just tell you the actions that I have taken so far. When Mr. Ray was named by the county as a potential witness in the underlying litigation, he was immediately removed from the investigation of the file, and the parties to the litigation were informed of that fact. The file was reassigned internally to another investigator, Mr. Jacobs. These are detailed in the report that I gave you. And then we began the process of Vincent and Elkins rightfully wanted to know if you're being named as a witness, then the counsel for the other side needs to know what it is you're going to testify to. And so they appropriately went through a whole series of requests for depositions of the parties. And they also made 2 Public Information Act requests. And over the period from December through April of this year, a series of depositions, and these are detailed in the report, were held. At this point, and I have read, as part of my investigation, have read all of those depositions. I have access to all of the exhibits that were provided for those depositions. The other thing that I wanted you to be well aware of is that since Mr. Ray was removed from being involved with the complaint, shortly after that I requested from the appraisal subcommittee that the complaint be granted specially documented circumstances status that exempts it from the 1-year requirement that we're judged on for resolution of complaints. And that was granted, that status was granted in December, and that paved the way for the ASC audit results, as you recall, from February. So nothing has been done to advance that investigation. The work is stopped completely. All of the materials were recovered from Mr. Jacobs as well and are sitting in a file box in the Enforcement Division and will not commence. The investigation will not recommence until after the litigation, the underlying litigation, condemnation litigation, is resolved. That was originally scheduled for April, and at the party's request, it was rescheduled for September. And so we will wait and see what what comes of that. Other things that I did that were that are, I think, relevant to actions that I took is I asked both of the parties through their counsel, and also our Attorney General also expressed this request to delist, to remove from the witness list any staff members of the board. It is my position that it is inappropriate for the board to spend any resources to benefit or to the detriment of any parties in a private civil litigation. And so we've made that request repeatedly. It's kind of a standing request that no staff member be named or called as a witness. That being said, however, I do not have any commitments from either of the parties in the litigation that this, in compliance with that request. I have no commitments that they will not be called. And so it will simply await the workings of the court, and if one of our staff members are, as they have been subjected to deposition, if they're also ordered to appear in court and give testimony, well then we will comply with the orders of the court.
Commissioner?
Yes.
I want to be clear about something, and I want to be sure that it was not my individual understanding of something. So it's true that when Mr. Griffin stood before us and the board requested Mr. Griffin provide his contact data to general counsel, that was me, okay? So I want to be sure that I'm clear that my intention in doing that, at that moment in time, on that day, was not to ignore Mr. Griffin's request that he be allowed to provide information to this board unfiltered from staff. It was simply my intent to be sure that we followed proper procedure. In other words, at that moment in time, I wasn't certain how to protect this board in its future need to address the disciplinary issue. And I hear in the briefing, because that was about the first paragraph of what you've given us, and I appreciate the thoroughness of the briefing. I hear in the briefing some indication that someone has taken that "please hand your card to our general counsel" as being some direction from this board that we want you to only communicate with general counsel. So I guess I'd open the mics to ask, to first say, that was not my intent. Was that the intent of the board? Because again, my phone calls from you don't indicate that to me.
Madam Chair, if I just might say that at the time, at the February board meeting, this item was not on the agenda. So the board had limited options as to what the board could do with this matter under the Open Meetings Act. It was not posted.
I'm aware of that, and I don't mean to interrupt you, but I don't think that has anything agreed. That's another reason I had him just hand his card to you. We couldn't do anything with it except direct him to give our contact information to you. So we were trying to work within the confines of what I understood our rules to be. I simply, and if your explanation is going to go a step further to explain then why there's an interpretation that the intention of the board was for him to only communicate with you, I'd love to understand that.
Well, the board's directive at that meeting, at that time, given the restrictions imposed by the Texas Open Meetings Act, was for Mr. Griffin to communicate with general counsel and provide information to general counsel.
In fact, Tony, can you pull up that same video clip? Because if you hear the entire, because I have listened to it this weekend, exchange between myself and asking Mr. Griffin to hand it to you, it wasn't to have you be the exclusive point of contact. I believe the communication will be, please hand it to general counsel so that the board can figure out how we're going to get in touch with you. We placed on you.
Chairman Wycliffe, thank you.
You can advance it, yeah, beyond Mr. Griffin talking and to the point that he's actually carrying his card across.
I've got limitations, and I've told you I'm not going to get into the substance of the complaint. Further?
Yes,
I
sir.
appreciate the,
I'd simply like to leave my business card so
There
you
you
know
go.
how to get
Stop
a hold
right there
of
and
me,
just let it play.
and wait to hear back from the board when you deem it appropriate or a board representative.
Madam Chair, if I may so respectfully request that this gentleman only have contact with our general counsel regarding this, and that he, as he has politely requested, he does not want to have to go through staff. Although general counsel is an employee, I would respectfully request that there is that direction, because he is asking for direction, and then I would ask that this board consider in executive session how we might go about handling this type of situation.
and I agree with that. If you would, our general counsel is present today, and if you would just leave contact information with her, we will be happy to, I'm sure, address this at some point in time in the future.
Thank you. I appreciate your time.
Yes, sir. Thank you for the public comment.
So the intent, at least my intent, when I asked him to hand the business card over, was that the board be in a position to address it at some point in time in the future. And again, that's no criticism if we've misunderstood each other. It's simply the opportunity for us all to get on the same page. This board may have had an intention of having him only communicate with you. And if that's the collective desire, I'm fine with that. I just want to be sure, because again, the phone calls I've received from you don't indicate to me that was your intention.
Madam Chair?
Yes, sir.
My understanding is, as you have outlined, I thought that it was to go to the legal counsel, and that was our point of reference for the contact to be made. That is how I interpreted it.
Okay. And I appreciate that. That may very well be everyone else's, because they're certainly being quiet, and if that's the case, I'm fine with that.
Madam Chair, that was not my understanding nor my intent. After the February meeting, I made several requests of you and of General Counsel to seek that request to be fulfilled. So that was not my intent, and it was not my understanding that the communication and information from Mr. Griffin solely be given to General Counsel. I heard it, and my intent was that she would be the contact person, the liaison between Mr. Griffin and us to make us available to him.
Okay.
Madam Chair,
Yes, sir.
also my line of thought about this too was that, of course, it was going to go to General Counsel, but just as Mrs. McClendon had mentioned when she was on the board here about going into some kind of executive session, or I don't know if it would have been the right spot to be executive session or a workshop or something on how to address these matters and how it would be addressed going forward and into the future. So I was certainly thinking that, you know, we would be briefed consistently on the matter until we came up with a plan on how to seek resolution.
I think that I concur with that. I just thought we were talking about the minutia of who was the contact point. And my understanding is the contact point was legal counsel, who would then get us up to speed on where we stood, how we were to handle it, what was the recommendation. Not that she was going to put some kind of a biased spin on it to protect staff, that she would give us the facts. And that's how I thought that would
And I
process.
And I want to be sure, and I appreciate the comment, because I think that's also what I've heard. I don't think there's any fear of there being a biased spin put on something. I think the problem is simply us trying to understand how and when we were supposed to get the information. We've been given dribbled, if you will, information over the course of time, mostly caused by pressure being placed on me and me calling and saying we've got to get them more information. That's the way I feel. Now, you all may feel differently than that.
Madam Chair, after the exchange between Mr. Griffin and the board at the February meeting, I explained the 4 options that the board had at that point, given that this comment was coming on a non-posted item. And one of those was to add the item to a future board meeting agenda. When Mr. Griffin contacted me, his information that he provided was that he wanted to report allegations of staff misconduct. And I asked him to communicate those allegations to the commissioner, because the commissioner has a statutory duty to manage the staff. And then I also communicated to the board that Mr. Griffin had communicated allegations of staff misconduct, and that the commissioner had been asked to investigate those allegations. And the commissioner had requested additional information to investigate those specific allegations from Mr. Griffin. At that point, it was perfectly within the board's authority to ask for this item to be placed on an agenda. And we had various conversations about what form that would take.
Agreed. Thus, we're here today.
Sure.
So let's again turn the clock back maybe to the very first concern that I've heard expressed by this board. And that has been part of the description given to us today. And I have, I guess, 2 questions. If, in fact, this staff became aware that this agency was receiving subpoena and our staff members were being deposed on November the 12th, why was it not until an individual stood at a public microphone was this board not given official notification of that, would be my first question. The second would be, at what point is it appropriate, and at what point did the staff and/or commissioner and/or you as our general counsel intend to give the level of briefing that we've received at our dais when we arrived today, but for the fact that we called for a special called meeting?
Let me attempt to address that. It is not unusual, although it's not routine, certainly, that that state employees are called to testify or named as potential witnesses in matters involving outside civil litigation. There is and the board has several safeguards, if you will, to try to minimize that. One is obviously when a complaint is filed, there is a question on the complaint form that asks whether or not this the matter that's being complained about is the subject of ongoing civil litigation. And in this particular case, that question was answered no on the initial complaint. And so there wasn't kind of an initial notice, if you will, that this was that this complaint had that potential, During the investigation of the complaint, it did become apparent that there was unresolved litigation open. It certainly wasn't communicated to me, but in general, the staff has works under the general directive policy that goes back to a time prior to the time when I served on this board, that we don't investigate complaints where there's ongoing litigation. We simply set those aside. Well, prior to 2013, that had no practical implications for the board with respect to our oversight audits by the appraisal subcommittee, because we had a large number of cases that were over 1 year old. And so if we just didn't investigate those and set them aside, they just became part of that bucket. Part of what changed the situation is that it became apparent, it was our goal, the staff's goal on behalf of the board, to reduce that to zero. And so the implications of that were that we should investigate all of the complaints and get all of those done. And since this complaint was filed in February of 2013, it would need to be resolved prior to ASC's visit in February of 14.
Commissioner, can I stop you for a second?
Certainly.
Again, I appreciate the point of reference, and I want you to be able to give the board the entire background. I'm not sure how that addresses the question, so I want to be sure I've made the question clear.
Okay.
At what point did you or our general counsel intend to notify the board of the issue in some formalized way, or do you believe, maybe the question is, do you believe you have no obligation, or that it is not this board's business to know that there is ongoing litigation involving our staff? Maybe the confusion is what our role is, and so I want it clear.
Sure.
Well, and I think if both Ellen and I could address that, in part because I became your general counsel on January 20th. So I did not become aware of these allegations of staff misconduct until the February board meeting at which Mr. Griffin spoke. I was aware shortly after I came on board that there was this underlying litigation, but I was not aware that there were any allegations of staff misconduct as a part of the investigation of this complaint.
Okay, and again, because of transparency and because I want everyone to understand, let me say on the record that while I recognize that might not have been true in terms of official notification, the issue as it relates to a problem on documentation has been brewing long since before then. In fact, it had to have been on your radar screen because as part of the hiring process, the day I interviewed you, I was talking to staff about concerns that I was hearing in the public. They were not official. We'd not received, I suppose, a subpoena, but it was not off of the radar screen of the organization. So at that point, I clearly understood why the board as a whole was not being informed because, quite frankly, it had not come to fruition. My confusion, and again, I just want to understand it, is when we did finally receive notice, I guess my first question is it this board's, do you as our general counsel or you as our commissioners see it as this board's business when our organization is and our staff is subject to litigation? If it's not, tell us so, because then we can mark it off of our list of things to worry about. But I've never been in public service where a staff member or our organization had a threat associated with it that I wasn't immediately notified by someone at a high level of administration. So I'm just confused about the process here.
Let me address that. Certainly if the threat was that the board would be sued for something, you would have been notified immediately. Because the notice that a staff member may be called as a potential witness in civil litigation, that civil litigation scheduled in April so 6 months hence, if you will, from the time we first were notified about it. Of course, we notified our Attorney General to help manage that matter. Our General Counsel at the time was dual-hatted. Ms. Lewis was well aware of it. I was obviously well aware of it and took steps to essentially diminish that threat. So did everything that we could to take, and I say threat, and it really isn't a threat. It's not a threat to the board in the sense that the board will be party to litigation. But it is potentially an undue, an uncalled for, if you will, an abuse of the board's resources. If staff spend an enormous amount of time on a matter that is not part of our charter, if you will. It's not the resolution of a complaint. It's involvement in outside litigation. And so I think the straight up answer is if we had reached a point where I felt that prior to Mr. Griffin raising the issue directly with the board, where I felt that the matter could not be resolved and provided and would have a significant impact on board resources, I would have brought that to your attention. Mr. Griffin brought it to your attention for another reason, and that's fine. And so here we stand today dealing with that. The litigation is still ongoing. There still is the possibility, I guess, that a staff member could be called to testify. The complaint matter is, we've done everything that we can to diminish the necessity or the impact of that, because we were unintentionally, if you will, dragged into this litigation. And that's the degree of that intention, I believe, when I characterize as unintentional, we were misled to start with, that there was ongoing litigation. Once we learned about it, there was exchanges of information, and some of those are the subject of the investigation that I am currently conducting to determine whether or not anything was done incorrectly or inappropriately by this board's staff.
And again, I appreciate the very thoroughness of the answer, but I need to understand at its core level. So it's the belief of the commissioner or general counsel that staff misconduct, accused staff misconduct, or the staff being exposed to civil litigation does not expose this organization and therefore does not require that this board be notified. Is that the interpretation I'm supposed to take from the explanation?
Well, there are two different things there, so let me try to address each one separately. It would certainly be appropriate for me as the commissioner to inform the board, as I suggested, at a point at which the resources of the board were unduly involved or are being depleted, if you will, by involvement in things other than the mission of the board. Okay, so at that point, if we reached that point prior to Mr. Griffin bringing it to your attention, I would have brought it to your attention.
So staff misconduct?
So that's the second part. Okay, the second part is the allegations of staff misconduct, and at this point, that's exactly what they are, is allegations. And until I complete my investigation, at which time I will, in executive session, inform the board on any staff actions that were what the result of that investigation were, and I think that's the appropriate time to do that.
So notification. I agree with you that actual resolution of the issue or the completion of the investigation information should only occur when you've had the opportunity to fully explore. I suppose my angst about the answer is simply that I've never experienced a situation that in an organization where the board might be subject to being asked a question on the street or by the press or someone else, that the person in charge not at least let me know something was out there. And so is it a normal practice in the organization that we would never notify TALCB if there was an accusation of staff misconduct until such time the process had been completely investigated?
The fact that an investigation is ongoing, I can't go back and create the situation differently, but Mr. Griffin appropriately, for his reasons, brought it to your attention, and the investigation was frankly already underway, but the majority of the evidence, if you will, is in or elucidated by the deposition process, and so I think that's it is very helpful to have that, the back and forth of the deposition as a way to get at the underlying both factors and potential motivations of staff during the time that the investigation of the complaint was ongoing, and so I have that, and Mr. Griffin and I have exchanged several emails, and as I said, I have read all of the depositions. I have access to all of the documents, and in the interest of making sure that the allegations, that I understand completely his specific allegations of misconduct, I've asked him to detail those. He has said that he would do that, and so I've done the preliminary investigation, if you will, but before I complete it, I want to make sure that I've addressed all of his very specific or his specific allegations of improper conduct, if you will. So during the process, and I want to make sure that the board does understand this, that in preparation for every deposition and immediately after depositions, of course, I have our general counsel from the OAG's office has represented the board staff as they go through those. And so I'm generally aware of the tenor of the depositions and now have spent some significant time poring over the details of those and solely await the specific allegations so that I can complete and conclude, if you will, this investigation and make a determination on what the appropriate steps are going forward.
Okay, and again, I just want to be sure, and I'm sorry to keep beating it, that it's clear to me. So the expectation that I individually had, that it was unusual for us not to be informed in a formalized way that something was going on, I seem to be hearing that that's not the way we do business, that we're not going to know that unless an investigation is complete or you have determined, you as the commissioner have determined that there's going to be an unusual drain on our resources. The fact that we have a risk, if you will, or a public image, if you will, or the opportunity for this board to be questioned about something with no background or basis is the way we function. And I will pause and allow for comment, but Ms. Lewis and Ms. Lewis was our general counsel at the time this was escalating, and so she's handed me a public comment notice, so I'll ask her after it appears our current general counsel would like to respond, and then Ms. Lewis, if you want to make your way to the mic.
Yes, Madam Chair, of course, if the board were named as a party in a lawsuit, that would be something that we would immediately notify the board, so that if you were to get a question, you would be aware of that and you would not be blindsided by that question. In this current situation, the board has not been named as a party. It has just been staff members that have been named as potential witnesses in the litigation.
And let me stop you right there, Kristen, because I want to be sure we understand each other. And I get that.
Yes.
So what I hear you all saying is that you don't think a staff misconduct allegation and the staff being involved in civil litigation exposes this organization as a whole, which we do have some responsibility to anything. Is that what I hear you saying?
No, I'm not saying that. If you'll let me finish my thought process. It is not routine for this board, and in fact, I'm pretty certain this is the first time that staff witnesses have been named as, or staff employees have been named as potential witnesses in a separate civil litigation proceeding. But in my experience in working for other state agencies, staff members have been called as witnesses in civil litigation based on their specific expertise, not as a matter of routine, but from time to time. So it hasn't been this board's experience, but in the experience of other state agencies that I have worked for, those boards did not feel that that was an issue that needed to be brought to their level of attention, specifically because that litigation did not necessarily involve the day-to-day operations of the board. If that is this board's desire, of course, certainly we would be happy to inform this board. But given the breadth at which other state agencies that I have worked for dealt with, they did not want to know every single time an employee was subpoenaed to be deposed in a civil litigation proceeding.
Okay. Ms. Lewis? I'm sorry, Ms. Montana, if you have something you'd like to say, you've reached for your mic a couple of times. I don't mean to stop you.
Ms. Lewis have the floor, and then I'd like to make.
Okay, just Carrie Lewis, General Counsel for the Texas Real Estate Commission, former General Counsel for the board. At the time in question, when we first found out about the subpoena in November, I'm just going to give you a quick background of that. We, both myself and Mr. O'Mixon found out about it in November. And the exchange that I had at that time with Mr. Griffin and his firm had to do with release of the investigative report through the open records process and all the objections that came to that. And we had a legal discussion back and forth on what we could or could not do, did or did not do, etc.
Excuse me. It was the release of what now?
The draft investigative report to the county through the public information
Thank you.
request. So that is what we thought the issue was initially. The deposition, and then I contacted OAG counsel because, as is our normal course in things like this, we do try to get depositions for civil cases or witness requests for civil cases. We try to get those quashed. We just had one on the Trek side that we did. Again, to Mr. O'Mixon's point about board resources. In this particular case, because the draft preliminary report was negative, was my assumption that the Vincent and Elkins wanted to depose prior to their case, so since the county had named our staff as a witness. I will say that immediately upon getting notice that our staff was named as a witness, Mark Murnack, our director, sent a notice to both the county and I don't know if he copied Vincent Elkins, but I know Mr. O'Mixon contacted them, but specifically said, we did not agree to be a witness. We are not signing an affidavit, which was sent to us unsolicited for expert testimony. We are not doing that. It is not the board policy, et cetera. That was sent out at that time in November. So it wasn't until the deposition didn't take place until January. So we didn't hear of these allegations of staff misconduct until the board meeting. There were accusations of staff inserting themselves into litigation, et cetera, but not of staff misconduct. So just to give you some perspective on the time frame.
Thank you, that does help me.
Madam Chair, just, I guess because all this information is great information, I think it's more pertaining to the details that we've been sort of kind of alluding to that we might want of the progression of this or any information that we have, but I'm still not hearing the question at hand being answered, which I thought we were on the question of how did Mr. Griffin's request, how was it handled? And just to clarify, I think Kristen almost got me there. Mr. Griffin requested something of this board. I still don't hear that his request has been attended to. Within that, I hear that, Kristen, your question of, is it our role to have that ability to have this information given to us? It might not have been in the past, but it is definitely our prerogative to have that if we want it. Is that what I'm hearing you say?
Certainly.
Okay.
And
that's okay. Just, yes, we can have that. All right, thank you. Then I think that's still where I'm stuck at. Mr. Griffin's original request to me still has not been attended to, and I want to know what this board, how we see it, and how we plan to address his request.
well, and understand that we do still have a pending complaint matter. And while Mr. Griffin requested that he be allowed to communicate unfiltered to the board, the APA requires that any communications about that pending complaint not be provided to the board. There is a strict prohibition against ex parte communications. So because these matters, the civil litigation as well as the complaint, are so interrelated, it is essentially my duty as your general counsel to preserve and maintain your ability to decide this complaint matter that comes before us, or before you ultimately, but then also to provide information that Mr. Griffin has given to the board or to me to communicate to you.
I understand that, and I appreciate that, and I want you to represent us in that position. My question still is, my question is, why has his request not been attended to by this board? Why has he not been able to submit to us information he wants us to have. Now, what you're saying is that when he submits it, it's your advice that it be ran through you before it gets to us. That's okay. I just want to know, has anybody been able to grant him his request?
Well, and I think
To
that
have a contact, to have an ability to contact the board without running through staff. Because it seems like Mr. Olmixon was saying that he went ahead and just continued to take care of it at a staff level.
I think that Mr. Griffin communicated his allegations of staff misconduct, and I referred those to Mr. Olmixon to investigate. And we have been in communication with Mr. Griffin on more than one occasion to ask for specifics about these allegations so that we can make sure that we address his concerns.
So in essence, what you're saying to me is that when Mr. Griffin sends it to you, you are going ahead and not responding to Mr. Griffin's request to not run it through staff because it's being ran through staff before it gets to the board. I want to know why, and this might be a very easily answered question, why Mr. Griffin's information cannot come directly to you, you filter it, and then come to us, because his request was that it not be ran through staff.
Well, and I believe that has been done. He made allegations of staff misconduct, and I informed the board of what his allegations were, and that Mr. Olmixon, the commissioner, was going to investigate those allegations of staff misconduct, since it is his statutory duty to manage the staff. If there was additional direction that the board wanted at that point, the board was certainly free to ask for that. But as far as I'm aware, those are the only allegations, the only information that Mr. Griffin has communicated to me.
Are you referring to the email that you sent out, the document with the 3 points telling us the progress of what you knew about the case so far?
Well, there was the attorney-client communication that I sent to the board, and then also we have communicated to the executive committee that Mr. Griffin had alleged staff misconduct.
I guess I'm still missing how that got to the full board for our knowledge. And just to make that clear, why I'm going there is because my whole intent, my whole desire was to have this full body kept abreast and informed of what was going on. And I feel like I was blocked, or the chair was blocked, at several attempts to get that accomplished until we're sitting here today.
Well, in addition, Mr. Olmixon gave a full report on his investigation regarding Mr. Griffin's allegations of staff misconduct at the May 9th board meeting. And at that point in time, the board had no questions of him about anything from his report. Essentially, staff has taken that lack of questioning from the board that either the board was satisfied with the information that the commissioner provided, his status and his progress report of the investigation, or that that the board did not have any questions regarding this matter at that point in time.
Okay, and so I appreciate that. I appreciate that interpretation. The two things I would say is I think part of what you should take away from that is this board's very diligent attempt to do what we hear you trying to educate us, and that is to be careful. So you haven't heard a lot of public questioning about this issue because, quite frankly, I don't think the board is comfortable with where the boundaries are, number one. Number two, if you think the 150 or so man-hours spent between yourself, the commissioner, myself, Ms. Fontana, and Mr. McAnally trying to address this issue over the course of the last 45 days was a lack of questioning on behalf of this board, maybe we need to talk about that someday, because I want to be sure, again, this for me, this is not a criticism, this is about, man, are our expectations unreasonable? Are we asking you all for something that we are not entitled to? If so, tell us on the public record. And if they are not unreasonable, answer the two simple questions we had. And the first one was, but for the public comment into the microphone, when would you have intended to tell us? And secondly, but for the angst that created this special called meeting, when did someone intend to give us a complete briefing as an entire body of what was going on? No doubt we've gotten pieces of information.
Let me attempt to answer those specific questions. So not being able to obviously go backwards in time and change any circumstances, at the point at which it was determined that, and this is a judgment call, truly a judgment call, that we were not able to protect or diminish to an acceptable level the administrative burden on the board from having its staff members involved in this outside litigation. I would have brought that to your attention, and I expect that would have probably been at through initial conversations. If you can imagine a world where Mr. Griffin didn't come in February and bring that to your attention, likely I would have done that privately at that time, as of course you were aware. Even prior to that meeting, we had begun. That's you and I,
yes, sir.
Madam Chair, that discussion. At what point does it merit, other than the commissioner's report, mention? Does it require an agenda item? And that really is a judgment call between the chair and general counsel and the commissioner, I believe, on that. The second question is, when would I have shared allegations of staff misconduct? Specifics of those allegations? Never. Never. Until those allegations were determined, until I could report facts, not just allegations. Because misconduct by itself is a conclusion based on facts. And so while I truly do understand the angst, I've had a few sleepless nights myself over the extent of the allegations, but until I can actually determine what all of the facts are, and really deal with, and this, as what I've tried to communicate to Mr. Griffin, is I don't want to produce an interim report that to the board, and then have Mr. Griffin later come back and say, but you didn't address this, this, and this. And so that's really been my request, is just for the allegations to be as comprehensive as possible, so that I can complete the investigation as comprehensively as possible, and report the then give you a status report on the facts. The presence of allegations, of course, you heard in February, and so they are what they are. They are allegations, and I am diligently attempting, and I've spent a lot of time trying to get to the bottom of that, and we're not there yet. We're still digging, and so as that process moves forward, as soon as I get to a point where I believe, because I share those findings with Mr. Griffin as we work along. He's given me some specific examples, but I've asked him for a comprehensive list, and if that's deemed to be somehow in an inappropriate response to the situation, then I would ask for clear direction that we can run through our general counsel. But I will tell you that both our inside and outside general counsels have been very clear about the absolute necessity of maintaining that boundary. So while it may be very uncomfortable to not know what all of those allegations are, they are very closely tied to the underlying complaint matter, and so it's my legal obligation not to pollute this board and to share them with you.
Okay, and I can...
Question,
Yes, sir.
Madam Chair, if I may. Mr. Commissioner, are you saying that any participation by the board into the allegations or investigation of staff would somehow require us to opt out of any voting or any review of that staff matter?
The potential exists, and it's a very tenuous situation, as you may imagine, may be able to imagine, that the board has to have the ability to hear the underlying complaint in an unbiased fashion.
Is that the same as reviewing the reports or any disciplinary action or any review of an audit, of a appraisal?
That's what's being done in conjunction with the complaint.
Okay.
Correct.
Well, first of all, I appreciate everything you said. I think you should have led with that, quite frankly. But I think everything that Ms. McClendon said at the last board meeting should have been the beginning, and my personal opinion, obviously, the beginning and ending of this inquiry, because we're not here to address Mr. Griffin's comments. I don't care about Mr. Griffin's comments. He has to go through staff. If everybody who had a beef with a Texas State employee came to a board member and said, I need to talk to you about my case, and I don't want to talk to the staff, well, then this entire state of Texas would grind to a halt on the heels of every lawyer that wanted to make a public comment. So I think we're wasting a lot of time this afternoon. I'm spending a lot of time away from my job addressing Mr. Griffin's case. I'm sure he's being paid to sit here. I'm not. If we have a motion to address here, I'd like to get to it. I don't know what more we need to beat this issue for, but I'm ready to move forward.
And I appreciate that. This meeting was called and this agenda item was called because there were members of this board who wanted the opportunity to have an open roundtable discussion. If everyone's issues have been addressed, I do have 2 people in the audience requesting to make public comment. So let's go ahead and hear those. As a matter of practice, this board's never denied that. So, Mr. Griffin, I'm sure I don't need to re-caution you about the concerns about not addressing issues directly related to the complaint.
Madam Chair, thank you for your time. I want to address succinctly about 3 or 4 specific topics that I think the board is wrestling with today. The first is, I again want to renew my request that I not be directed to only communicate my complaints, the documents, the information in support of what I believe illustrates staff misconduct through Mr. Oldmix. And it's a very simple and it's a very basic explanation. There has got to be checks and balances in any level of government as to what is provided to that governmental agency, how is it reviewed, and how is there then a finding that is a finding that is supported by the facts and that everyone trusts is the right result. Specifically on this situation, Mr. Beard, I'm going to use your comment. You opened up with a very good question at the very beginning. You said it appears that Vincent Elkins has a flood of information they want to provide the board, and we're talking about what's the avenue to try to get that information to the board. You are correct. I have a flood of information that I believe this board, or a board representative beyond just Mr. Oldmix and the commissioner, would like to become aware of, so that you have a system of checks and balances, because these are serious allegations of staff misconduct. I do not make these allegations lightly, and I do not make these allegations without first having looked at volumes, thousands of pages of documents, taken depositions of TALCB staff members, some more than once, and obtaining documents and information not directly from TALCB, but in the underlying condemnation case that deal with what I believe are the inappropriate communications between Harris County and the TALCB staff members involved. It is a flood of information, Mr. Beard. And here's the problem. The problem is for one individual who has not been involved in that flood of information, specifically Mr. Oldmix.
I apologize for interrupting, but I think it's important to know that I can take it here on the microphone. I apologize, Madam Chair.
No. Sorry.
It is not fair to Mr. Oldmixon to put him in the position of trying to conduct an investigation and make a finding to this board about a serious allegation of staff misconduct based upon him reading depositions, because quite frankly, that's only a piece of the puzzle. You have to have the context of the factual background, having reviewed more than 3,000 pages of documents and done the depositions themselves and looked at everything in relationship to those before you can make an honest and open assessment about whether misconduct existed or not. And quite frankly, my goal, my purpose is to be the conduit to answer information and provide documents so that you can have a reasoned, accurate determination about whether there was misconduct. My problem is this: if you make me go only through Mr. Oldmixon, then ultimately you as the board, in my opinion, are someday going to be sitting there when Mr. Oldmixon makes a recommendation or gives a report about whether there is staff misconduct or not. And you're going to have a world of questions about various things that were either looked into, not looked into, documentation and testimony on particular points. And unless I've had the opportunity to educate not only Mr. Oldmixon, but somebody who is a board member designee on those things and be a conduit to answer your questions, that quite frankly, I don't think that you're either going to be satisfied with the basis for which you can make your ultimate opinion and determination and accept or not accept Mr. Oldmixon's report about whether staff misconduct occurred. I'm trying to be the person that, quite frankly, having gone through all of the documents and the depositions, is the most likely person and the most reasonable choice to provide that information. That's number one. Second, Mr. Barber, look, I understand. First, I'm not getting paid to do this. Hard to believe, but in light of what I have seen, there's no Vincent and Elkins client paying Donnie Griffin to be here at TALCB. Secondly, and importantly, the specific allegations of staff misconduct, I was disappointed that the board did not direct me to someone in addition to only Doug Oldmixon to communicate. And I want to make something crystal clear. The general counsel said that I wanted unfiltered ability to communicate information. I've never tried to exclude Doug Oldmixon. I said on February 2014 he should be a part of my discussions and the investigation, but very importantly, there should also be a board member or a representative of the board beside a staff member who also participated in that. I understand that there's a fine line between talking about the substance of the findings against Mark Sykes, the appraiser, out of which this misconduct arises, and setting that aside on one hand, and separate and apart from that, talking about and giving examples of sworn testimony, documents, and facts that would lead someone reasonably to believe there's been staff misconduct in the investigation. I've prepared about a 20-page letter that has exhibits and that sets forth a summary and a starting point for the investigation. It is impossible to put in one document everything that is related and should be considered in the ultimate determination about whether there was staff misconduct or not. But Mr. Oldmixon has requested, and I have prepared this document, and I've got multiple copies, enough for the entire board if the board chooses to do that. My reluctance in providing it until today, until we had a formal agenda item where I could get back before you, is I am concerned and continue to be concerned if all I am doing is merely handing the information and the documentation to Mr. Oldmixon and no one else. And that includes General Counsel and Ms. Samuth. Look, they're fine lawyers, but they are not board representatives as far as I am concerned. So again, I am trying to be not the individual who all information is filtered through, but an individual that if you have questions about what happened, why, and who said what, and where is it in a document, Mr. Oldmixon does not have the ability to answer all those questions because, quite frankly, he doesn't know them the way I do.
Thank you, Mr. Griffin. Are those your points?
Yes, and I've got multiple copies. At the conclusion of this, I'm happy to hand out to whoever the board directs me. And again, this is not a matter where you can read the depositions of TALCB staff and then say yes or no, there was misconduct. There's a lot more to it than that.
Thank you. And that's why I wanted, again, the board to hear the entire conversation. There was a point in time in this discussion where I believed there was acceptance by the commissioner, acceptance by general counsel, a willingness on my part to abstain from any future disciplinary vote on this issue so that we could accommodate the public request. I do not want to independently do that without the board's concurrence. So if you agree, that's a potential for a motion. If you disagree, that's fine. But I think the concern that has been expressed by multiple board members to me is simply that someone made what seemed like a reasonable public request and that we had not been able to either give him a legal reason why we can't or advance the process. And so, again, the mic will be open. I have one other individual asking for public comment. So, Ms. McClendon, if you'd like to make your way to the mic, if there's any board comments, I'm happy to take those.
I only have one question, Madam Chair. Should there be a split between the board, who would give the deciding vote? Should you recuse yourself from the process?
Good question. I suppose there wouldn't be someone to do that. Ms. McClendon, if you'll state your name for the record. Ms. McClendon is a past board member, but the public record needs to be clear.
Yes, Madam Chair, and not fellow board members. My name is Shannon McClendon, and I'm a former board member. And I want to make sure my mic is on, so in case you call this back, it's not me mumbling.
I'm getting a thumbs up in the back. Thank you.
And I appreciate Mr. Barbaro's something like that. Yeah. Position in that right now, as I stand here and have worked hours on this, as not a board member, I am not getting paid, but more importantly, I'm not earning my living as I stand here at my billable rate. And so I think that should at least give you all a heads up a little bit about how important I think this is. I was on the board, I think that most of y'all know, during part of the concern we had about the Sykes complaint and it not coming before us, and it was in an enforcement meeting that I believe the chairwoman was the chair of at the time, that we found out that some of our board staff members were being deposed. And we said at that time that we found that really important, and I understand that the new general counsel was not there then, but Ms. Lewis was there, that we want to know anytime our staff is being deposed because we're finding out about it from the outside world. And if we're finding out about it from the outside world, as a former board member, we get phone calls from the governor's staff or advising committee or whatever else, and we don't know anything about it. So it's nice that we have the heads up ahead of time instead of being a deer in the headlights. So I think that was known. I don't know it was at least in one of the enforcement committee meetings. I don't know the date of that. Since I've been off the board, I have had some time to talk with Mr. Griffin, and I have not had a single issue with separating out the procedural issues regarding alleged staff misconduct and what goes on in the complaint. And I think that the materials that were put together by, thank goodness, Mr. Griffin's office and not mine, because I don't have the resources for that kind of thing, to just do without any kind of pay. Maybe if y'all don't want to look at it or take a 5-minute break, or I don't know if y'all intended to go the whole afternoon, have general counsel look at it, have outside counsel, see if there's something that needs to be blacked out, because there is no intertwining of what is said in the complaint. I haven't read the complaint. I don't even know what's in it, and I don't need to know that. As a board member, you should want to know when there are allegations of misconduct. Not whether there is, just that it's on the streets. The governor's office knows that there is some staff misconduct. Whether or not the commissioner should have known back in the day the complaint was filed and Mr. Ray took it, that there was an ongoing investigation, he sure as heck should not have known. He doesn't micromanage the staff. I do think there is probably a policy that needs to be put in place for this not to happen again. There is a problem that happened. And in fact, my understanding, have not read the complaint, is that the box was not only checked no, but there were handwritten notes, and I would imagine council can verify this or not.
Ms. McClendon, that's starting to sound like
No, this is procedural only. They talked about, that's already been raised to you, Madam Chair, that what box was checked or not. I don't even know what the grounds of the complaint are, whether they're frivolous, whether they're horrific, and Mr. Sykes should have his license pulled. I have no idea.
Okay.
But the outline that's been established of what happened on what day, and more importantly, what did not happen, the conduct that Mr. Ray, one of your investigators, had with an outside counsel, a government employee with Harris County, knew there was ongoing litigation and continued to proceed and pretended, gave the draft investigative report over. So these are all procedural matters. Y'all can hear this stuff. What I would suggest, besides taking the time to have staff, general counsel look at this, is there are some simple things that I think that y'all can do besides what's probably obvious already. Madam Chair, you've probably already figured this out, and I hate it. I'm not being instructive. I'm hopefully being helpful. That make it clear to staff that the board needs to develop policies that this doesn't happen in the future, that you're made aware of it. But most critically, there needs to be a letter from the board that says draft independent reviews that go out are not evidence to be used in another case. I am not involved with the condemnation proceedings. I do transmission line routing, which is a process that takes place well before the condemnation world. The industry right now for the appraisers is in a destructive mode if we continue on the path of allowing someone to file a complaint against someone while there's ongoing litigation, hence why we had that box there. So if anything comes of today is a letter or an agreement or something that says board letterhead, draft investigative report, has no evidentiary value, has not been reviewed by the board does not take a position on anything like that, and by definition with it having draft, it's not a completed report. I'm here as a resource if y'all want to continue to deliberate any of this today for any questions you may have of me. I feel like I can be a good filter for you, and I would like to work with general counsel on where they find it so intertwined that they can't separate it out.
Thank you. Thank you. All right, now we have heard from all of the public that had requested the opportunity to speak to the board, so the floor is open. Yes, ma'am. Then thank you for your time. The floor is open for motion, comment, question.
Okay, I have a question, Madam Chair. This is probably too off subject, but what if, hypothetically, we're talking about issues that, and this is probably not a good example, but what if Kristen got a DWI? Well, then what if she got a second DWI? Or, something like this,
Kristen probably appreciates you using her as the example.
How much, does the board, anything that we're working with in these alleged, if we have something that's alleged, and what I hear the commissioner saying is if it's alleged, I'm not trying to bring this to the position of being, I don't know how much, well, that's pretty serious. She got 3 DWIs in 6 months. Maybe we need to do something with her, but I don't know if that may not be relevant, but
I think the difference between those is whether or not the allegation creates exposure for the organization. Your example or the potential for anybody on our staff to have DWI issues is not directly relative to the concern that has been expressed by other board members and myself, and that is, at what point is it the board's role to understand risk? We've had a lot of conversation about that. I agree with Mr. Barba. It's getting late in the afternoon, and we're on agenda number 4. We are here because you all asked me to assemble us so you all could talk and make forward progress. If the forward progress is we're pleased with where things are, then we can move on with no action.
Madam Chair, I have a question. Earlier in our Ms. Carey, our former counsel, mentioned that a document had been put out. That's why I stopped to make sure. What was the impact of putting out that document, or who put out that document, or what happened? What happened there? I need to get some clarification on that. And is there an impact on that?
That was an investigative report. That was a preliminary draft investigative report. And I think you have an agenda item later today talking about the process of giving that out. There is a rule. Am I on? Okay. I think the light's out here. I think that's the problem. You can't tell. So that document was given out to both the Respondents' Council, Vincent and Elkins, and to the county, as they were. First one was representing a respondent in the case, and there was talk with the attorney on the case that there was going to be an informal conference, and the rule that the board has says that that has to be given 3 days before an informal conference, and it was requested. So that was sent out.
Since when did we come to that conclusion that information goes 3 days before?
It was in a rule put together by the Enforcement Committee sometime, a year ago, maybe by now.
The actual effective date, or excuse me, the board at its August of 2013 meeting adopted that rule. That was the final adoption. So it had been proposed in May, and based on a recommendation from the Enforcement Committee, and it's appropriate, but it dealt with transparency. So you didn't want an appraiser who was the subject of a complaint to be blindsided, if you will, by what was going to be talked about at the investigative conference. And so those reports, yeah.
If I may, Mr. Commissioner, as one of the committee members that sat on that board while this rule was being made, there was absolute no intent by that rule for a draft to ever be part of something that was released from this agency, first of all.
And second of all, I thought that information was going to be only going to the appraiser that we were talking about. What does that have to do with giving out to a respondent and all this other stuff?
If I could address that.
Yes.
The board adopted this rule.
Yeah, but that was not the intent.
Well, that may not have been the intent of the board, but once you release a document to the respondent, and understand the investigative report prior to an investigative conference will always be a preliminary or a draft report, because it cannot be finalized until after that investigative conference is held. So when we release that report to the respondent, then under the Attorney General's opinions that have been given to this agency in the past, that document is open to being released to any party who requests it under the Public Information Act.
That was not the intent of the request at that time, as far as I'm concerned. And I may have him interpreted, but if that's what it was, that was not the intent. One thing was to help the respondent understand what he was coming to, but it had nothing to do with going out to the public, because it's still not finalized.
And that may well be the case, but we have no statutory exception to protect the confidentiality of that document from release or disclosure under the Public Information Act if it has already been released to the public outside the walls of this agency, including the respondent.
Well, something is wrong, and we need to correct that immediately.
And we do have on our radar screen a request for a statutory change that would protect these reports from going out in the future to people beyond just the respondent. But absent that change, one of the agenda items up for discussion in this meeting is a discussion of this rule, the board's intent behind adopting this rule, and what we can do in the meantime to prevent this from happening again.
The floor is open for the board. Yes, sir. Mr. Commissioner?
Just one additional comment that is, I think, consistent with Ms. McClendon's suggestion that the board adopt a policy that essentially states to the public that a draft preliminary, I mean, put as many qualifying words on it as you want up front, but a draft preliminary investigative report has the words that I used in a conversation, in a communication with Vincent and Elkins, and that they have used as well, and I think appropriately, as I stated that in fact it has no probative or evidentiary value, in my opinion. Now, whether or not it has either of those is always up to a judge to decide in the end. But I'm willing to stand for the board and say that is our policy. This is the beginning of, we've heard essentially we've looked at some documents and come up with some items to discuss as we continue this investigation. And so in the conference, we're going to be talking about these things. There's still much more discovery to be done during that process before it has any before any conclusions can be drawn, and before it has the kind of value that that a final report would have.
Thank you, Commissioner. Okay, in an effort to move us, as I understand it, the options that we have are to just move on because this board has now been briefed and you have no action, that you can give some direction or make a request or motion as it relates to whether or not we want. So if we move on, please understand that I would assume by moving on that we mean to be sending the message that we're going to continue down the path that we're on. But we were all now at the table and have had the opportunity to participate in that decision, or that there's some other method that you expect to be communicated with as it relates to this issue.
Madam Chair, so basically you're saying that you will recuse yourself from this particular case and be the liaison between the information that needs to be submitted to us? Is that what you're talking about?
I have in the past volunteered that. I understood that to be an acceptable solution between the commissioner and our legal counsel. I continue to be willing to stand in that gap if that's this board's desire. I simply have never wanted to take that as an independent action without this board understanding and actually having a voice in that. So some of you may feel like that's not appropriate, and I want to be sure we have discussed it.
So by moving along, is that one of the choices or not one of the choices?
Now, I would ask if we're going to have that as a choice, that it actually be in the form of a motion so that there's never an accusation someday later that I independently took that position. I would expect that moving on means that we're happy with the process that we're in. Now we're all equally and fully informed, all with the same information on the same day, and we can move on. Or that you want to do something different.
Madam Chair, if I may.
Yes, sir.
I feel this has been very cathartic. I think it's been important to have this meeting. I think I'm not on. I am on now. I think it's been, this catharsis has been good for us. It's been important for staff to know the intentions and the will of the board. I'm glad that we had it out. I'm glad you're involved. Well, I think you're going to be, first, I think you're going to be removed from voting in the future on some of these things, but that's between you and GC to determine. And I think we've vetted this out as much as we could and dedicated as much resources to this as much as we should. And along those lines, I would ask the chair to move on to the next agenda item. I don't have any motion to give, to present.
Madam Chair, I'd like to make a motion.
Okay, Ms. Fontana.
I don't know how to do this very well, but I'm going to try. I'd like to move that this board recommend you as the liaison or the contact for Mr. Griffin to be able to have any kind of transfer of information that he has, which per his discussion, I believe you have current information you'd like to give to this board in your hand right now. And that you be that liaison representing the board for the time being. For the time being in this case.
Okay, we have a motion. Is there a second?
I'll second.
We have a motion and a second. That takes us to discussion. Again, I am willing to serve in that capacity. I want to be clear with the board that that does not mean I will be communicating with you about this issue. You'll still continue to receive whatever communication you have through our general counsel. In other words, if I'm acting as liaison, I'm only going to be receiving information. I won't be giving it to you. That's the way I would understand my role to be in order to protect the board's future action.
Madam Chair, if I may.
Yes, sir.
I would vote against that motion. I think maybe just because I'm naive enough to do so, believe that we should have faith in our staff to handle these complaints and not to set another precedent for a precedent so that if there is yet another complaint along those same lines, we have to do the same thing, or we would be abusing our discretion somehow.
And I appreciate those comments. I think that is something that has to be taken into consideration.
And I don't know if I'm echoing Jesse's concerns here or not, but I just wanted to say for the record, if this motion is presented as it is, it does not become a template for future issues. I think this board should maintain its flexibility and be able to approach issues and problems on a case-by-case basis. Furthermore, and I'm not going to make that as a motion today, I just want to reserve the right to think about in future. I think there was a couple of dynamics working here today, but one of them was that I think the underlying current, and it's not an easy answer either, but it's the board, they want to know where the thresholds are. We don't care about day-to-day management. We don't care about the staff management on a day-to-day basis, but where does things get elevated to a point in time when then maybe we should be notified, not making judgment, but just being notified that this is occurring. Mr. Griffin came here on February, and I take it, did any staff members know he was coming? He took it upon himself to approach the board. And Jesse, this may kind of run counter to some of your thinking, but the history of this board is that anybody can come to the board and address the board, whether it's an investigation, whether it's an observation, whatever it may be, they're welcome to address the board. And I think that Mr. Griffin did that within the boundaries of our established businesses and protocols. So.
And just to add clarification to my knowledge of it, I do think it's very important for this board to always maintain transparency and to always be able to be willing to hear anything that the public has to say for us, because I think there is a process that we do have to keep a good balance of power in here. And if we ever start getting to the point to where we are not comfortable with what we're hearing on the street, I think we need to be able to be approached to obtain information from anybody that has something for us to hear. Also, not to amend the motion, but I do understand that Mr. Griffin will use the avenue of our general counsel before it gets to Ms. Wycliffe as a filter to make sure that anything in his information that he's submitting to Ms. Wycliffe is not substantive. That's my understanding by that motion, that would be the route.
Any additional discussion?
I have one comment, just for clarification. Are we suggesting, is Mr. Griffin suggesting that the information he's sending through the protocol that we currently have through legal counsel, we've got two legal counsels sitting here in our presence, and a commissioner that's also an attorney, is he suggesting that somehow we're somehow getting biased feedback from them, that we're not getting the true story I just don't see why we would disturb our protocol that we have established. Much like what Jesse is saying, it seems to me like we have a check and balance system. You got two legal counsel, they can't one be staff and I mean, they're both, somebody's got to be representing the board there, that we have independent counsel that doesn't have a vested interest in somehow protecting staff from some, something that we shouldn't be hearing. So I don't understand why we need a board member, what that is going to add to the mix. Why would a board member hearing the complaint help?
Well, and the wrestling that we're having at this moment is exactly why we've been since February to today with no forward progress. So I do hear lots of good discussion, lots of good comments, and we do have a motion and a second. Based on the comments, I believe we need to do a roll call vote so that there's no confusion about people's positions. So I will start to my far right, Mr. Barba. The motion, of course, is to have me serve as the liaison, and your vote, yay or nay? Nay. Okay. Mr. Padden?
Nay.
Mr. Garza? De La Garza, sorry. Yay. Okay. Ms. Fontana, yes. I am abstaining. Mr. McAnally?
Yes.
Mr. Beard?
Nay.
Okay. Can somebody give me a tally, please? 3 and 3. How fantastic is that? Floor's still open for conversation.
May I offer?
Yes,
something?
Mr. Commissioner.
Okay. So with the understanding, and I hear very clearly the anguish, if you will, of trying to resolve this particular issue, I do believe that it's important, and so I'll address this to all of the board members, except the chair, that the chair has been in significant conversations with myself and general counsel about both matters, the litigation and how that's affected the staff and the underlying complaint, and where those boundaries exist and all of that. And because, as you heard the chair say, she already intends to recuse herself because of the amount of outside information that she's become aware of just in her professional practice. I would urge the board to, in this one case, Mr. Griffin is asked specifically, for the right to communicate information to the board, unfiltered by staff. And I mean, I understand. I understand his desire there, and I'm I was actually touched by his concern for how unfair it would be for me to spend, read 3,000 documents and all of that kind of stuff. But it's part of my job, just like it's part of your job, and so I will, as a part of my investigation, investigate every piece of evidence that's relevant to the allegations that are coming forward. I think because this is a unique situation, Mr. McAnally's intent that this not establish a precedent, I would urge the board members to allow the chair to serve in that role, because I believe more positive will come out of it than negative. And if your concern is that we establish a precedent, or that it somehow would negatively affect the staff, that we're kind of a vote of a lack of confidence in the process, or any of that kind of stuff, I believe that the goodwill displayed by the board and the chair in this regard to deal with the substance of this and get through the process while preserving the board's independence, I would urge you to take that step, take that leap of faith, if you will, and allow her to serve in that role and let the process move forward. I believe that this will be resolved this year. As soon as the investigation will.
That's comforting.
Assuming there's litigation, that the litigation goes forward in September as it is scheduled, or settles, or however that comes out, and we can and we can get back to the business of dealing with the complaint, prior to that time, we will have dealt with all of the internal, the actions of staff and evaluated whether or not, and I really do want, as Mr. Griffin suggested, and I believe I heard others echo, don't want there to be a future date at which the board says, you know, I wish we would have handled that differently. I really do believe that, especially since the chair has already agreed to recuse herself and feels very comfortable and maybe even compelled to do that, that we should take advantage of that and allow this process to move forward. I believe it'll benefit Mr. Griffin and his clients. It'll help us get to the bottom of the facts, the investigation more rapidly, and I think most importantly, it will help us, as Ms. McClendon suggested and others, to define for all of us where that intertwining of interests and prohibitions, you know, where we get to that dangerous boundary that it's just it's a slip of a tongue, if you will, whether it's intentional or unintentional, that inserts some fact into a discussion that then changes a mind and potentially biases that individual in the board. And so, since since our chair has agreed to serve in that role, that danger is highly mitigated. And I would really encourage the board members to take advantage of that, and let's get through this. Let's get through this process.
Excuse me, may I speak?
Yes, ma'am.
Madam Chair? I've been quiet for this whole meeting, but I think that the whole board knows how I feel about this issue. But what I would ask the board to do, instead of asking us questions, my question to the board is, ultimately, what is your goal by having a conduit by which Mr. Griffin can get information to the board about this? We all know that the duties of the commissioner include managing the day-to-day line staff, and there's no question that this falls into that category. Now, I understand everybody's concern that the board is possibly being maligned or is being open to being dragged into litigation. You're not open to being dragged into litigation. You're not being maligned. I understand that you're being approached by members of the public and you don't know what to say. And I understand that that could be, Jamie, you're shaking your head.
I think you misunderstand, and so I want you to finish your comments. I do not want to be guilty. I'm guilty often enough of interrupting someone. I do not want to be guilty of that.
But if I've misunderstood something you said, stop me before I continue, and then I'll continue.
Okay. You asked the question, what is our goal? I can only state for myself, number one, to honor at least the request by performing the request, which is to provide the liaison, or providing justification for having not. Simply not let it sit from February to next February with no direct response from this board to the direct question that was asked. That's my number one goal. My number two goal is I can promise you, Ellen, that the operation in its as-is mode is putting this board at risk.
I'm sorry, the operation in what?
In its as-is mode. Continuing down the path we're currently on, in my opinion, puts this board at a huge risk in the future when it has to deal with this disciplinary issue, simply because of what's going on in the background. It is way too dangerous, in my opinion, to continue in a status quo method because there's far too much casual conversation, and in fact, every time we meet on this issue, another factual piece of information gets dripped into the process that makes me nervous. That was solely the reason I volunteered to be liaison, so that we could stop that outside conversation, not because I have any more time than any of the rest of you that are volunteering, nor do I want to be any more involved in this process than need be. But I saw a risk from my position to this organization, and it's my job, just as it's yours, to try and protect it at the level that I can. Now, again, I've received mixed communication about whether that suggestion would be successful, but that's the two things I was trying to accomplish. Honor the request or respond to it in a way that was reasonable, and then finally eliminate or at least reduce the risk that this entire board was going to find itself unable to vote on a disciplinary issue in the future.
Well, I'm not sure how not having a liaison and not getting involved in this would have the potential for disqualifying this board from voting on this disciplinary issue in the future if you're not involved.
I understand, because you don't understand what's going on in the public. And that's what we are trying to make clear to you, that the casual conversations that start as casual, every time one exists out in the marketplace, it creates the opportunity for additional information to get discussed. Where if, and again, I got plenty to do. I'm not lobbying for a job. But if this board could say simply, I'm sorry, I really can't address that issue. That's a future disciplinary issue. However, our chair is acting as a liaison, and that's the way we're handling it. It simply eliminates the casual conversation, because it never starts with someone's intention, in my opinion, to put the board to put the individual board member in a position of non-voting. But it is, Ellen, and make no mistake about it, and we hear a lot of these, so please understand, when it raises my level of angst, it's not that it's a casual problem. It's that I'm hearing it in far too many places that starts with a, hey, I hear you guys have a problem, and quite frankly, we've been open about it today. This doesn't happen often, so it's a great conversation starter. And it's a difficult conversation ender. And so all I'm trying to do is find a way to stop the various people who are curious from addressing all of us. Maybe it won't, but we were just looking for solutions.
And I understand that. And I understand that you're approached and hear things around in the marketplace, I think you put it. But the problem is, you can't stop those conversations. It may be difficult, admittedly. It may be inconvenient, admittedly. It may not be how you want to conduct yourself, admittedly, but I think it's doable. It's no different, really, except perhaps in volume. I don't know, because you're right, I'm not out there, than any other appraiser who finds themselves on the wrong side of a disciplinary action or a potential disciplinary action where they call a board member up, and this occurs with all boards, not just this board. They call a board member up and they want to talk about it. This is just like that, except that it appears to be more serious because this is attached already to somebody else's litigation, but not the board's litigation. And never lose sight of that fact. The board is not a party to this. You've got some witnesses, maybe. You don't want to set a precedent for everybody to be able to come and request a liaison. I understand that you already said you want to make it part of the motion, that that's not going to happen and that this does not set a precedent. I'm not sure that's going to be fruitful, but certainly you can do it. I don't know. I'm just trying to protect the board and keep the board from doing something that it has no authority to do, even if it is managing alleged staff misconduct. In fact, there is no staff misconduct yet that we know of. There are definitely allegations. But let's assume that some of the information that the chairperson receives indicates to her that there's staff misconduct. What are you going to do? The board doesn't manage the staff.
And I clearly understand that. I believe that that's why the commissioner is probably comfortable with me being in that position. And again, to make the record abundantly clear, our goals are common: to protect this organization. I understand your comments, and I understand your desire to protect the organization. It's precisely why we're having this now 2-hour conversation, is because it's a difficult situation, and this board is trying to protect this organization as well as you. So I do appreciate the comments. As you well know, I've heard them once before.
Yeah, and let me just make one last comment. Aside from protecting, or I should say involved in protecting the organization, is a protection of each individual member of the organization.
Thank you. I think we understand that.
Thank you.
So the floor is now open. There is a motion that essentially ended at an impasse. My guess is if you want to continue additional action, we need either a new motion or a revote. What's the desire of the board?
Madam Chairwoman, I voted nay initially because I do feel that the motion undermines the duties, the roles, and the responsibilities of the commissioner, as well as legal staff, as well as the staff of this board. And I know that Commissioner Olmixon made a very compelling argument why it makes sense, but that's why I voted no. I really do believe that it undermines his duties and responsibilities, as well as legal staff and the staff of this board.
I heard a couple of requests to revote.
The motion failed, so there would have to be a new motion or a repeat of the previous motion raised again and then seconded.
Thank you. What's the desire of this board?
Madam Chair, may I make a quick comment, please? Less than 30 seconds.
It would take me longer to keep you from doing it, so please hurry, because it would normally not be something I would allow.
I know that. Again, Shannon McClendon. I think, if I understood correctly, the commissioner here is in support of the motion. Is that correct, Mr. Oldmixon? Did I understand? Okay, I thought that's what I heard. So I think that he gave good guidance, maybe that you do recommend for another vote, since I think he's asking for support here. So that's the 30 seconds. I think it was actually 25.
Thank you.
Madam Chair, I'd just like to repeat my motion. Do I need to do it verbatim? Would you please read it back for me?
Would you like me to attempt to restate what I believe to be the motion?
Yes, ma'am.
I believe there was a request to allow the chair to act as a liaison on behalf of the board in this singular situation to accommodate the public request as it relates to, I don't know how to clear,
Mr.
Griffin's submitted request.
So moved.
Second.
We have a motion and a second. We'll again open the floor for discussion.
Madam Chair, if I may reassert my prior comments and just add that I'm proud of our commissioner for falling on the sword here. If he didn't do anything but support someone second guessing him, he'd be a bad commissioner. But I don't think that's a reason enough to vote for the motion. It's short of me finding out he's some kind of vampire at night or some reason that I need to doing something that's evil and malicious. I don't think that there's a reason to second guess or miss that. Thank you.
Appreciate the comments. The floor is open for additional discussion. Hearing none, again, we'll call for a roll call vote, starting with Mr.
Madam Chair,
Oh,
just
sorry.
one more clarification. You said that regardless at this point in time, your involvement in this matter, that regardless of how the vote goes down, you would be recusing yourself from a vote on this?
That's correct.
Okay, Madam Chair, for clarification, I know we've said it a million times, but tell me exactly the benefit. You're going to get information. You're going to get information to interpret better than what the commissioner or legal counsel can get, and you're going to feed that back to us through an unbiased sieve. I still don't grasp the real concept of having a board member feed us information back that we're not getting. I don't get the real cause of this.
and I appreciate the question because I think it allows for clarification. It would not be my intention in this role to continue to feed additional information to this board, but simply potentially give you confidence or support that someone other than the commissioner has looked to the entire issue. So two things would be accomplished by it. Number one, we've heard and met the request, albeit an unusual one. We've heard and met the public request. And secondly, that at the point in time, maybe there would be the potential to have less second guessing of whatever the conclusion is as a result of the investigation. So another set of eyes.
Okay. Okay. So in the public interpretation of the board's actions, it's not perceived as a biased, staff-driven decision. We had a board member in the loop as well, so the board can't be then criticized for allowing staff just to drive the decision-making process.
And I think it's really more an absorption of the information because, again, I want to be clear. I echo the desire to not undermine the commissioner's role. I have regularly made public comments. Not my job to oversee his staff, and I don't intend to be giving direction as it relates to discipline, but simply receiving the information through an additional set of eyes and being in a position potentially to support or at least give him the opportunity to have someone on the board to bounce his ideas, resolutions, whatever, off of. So the conversation, as I understand it, would be limited to the commissioner and I. I would not be trying to influence the board at some point in time in the future.
I guess my problem is we're talking about policies and procedures, and so now if we go back and we look at how do we handle this case in the future, we're saying this is an isolated case, we'll never do this again. We guarantee we'll never do this again, but in this one isolated case, we're going to change the policies and procedures because we have a perception that there's misconduct on the part of the staff or something like that.
Well, let me just be blunt. We have an obvious confusion and/or split as it relates to the board's position, and it's causing a lot of trouble. It's causing a lot of man-hours on behalf of the executive committee. It's causing a lot of man-hours on behalf of your staff to wrestle with this. How much information are we supposed to get? Who's got it? Why haven't I been told? And so I think the only common goal was the ones I've so stated, to be able to respond to the public request with either a legal reason why we're not going to talk to you or some method by which we can accommodate the request.
Let me ask you something right there. You said how we're going to talk to you. So you as a board member then are going to be able to communicate directly with Mr. Griffin and say, here's how we've decided this is going to come down? Is that what you're saying?
No, I don't. I'm not going to have a voice in that at all.
Well, how is that getting what his request? How is that accomplishing that? If he wants to have direct communication with the board.
He wants to be sure someone other than, here's what I understand it to be. And again, I'm now with you, Mr. Barba. I wish we had just moved on about 30 minutes ago. What I understand is he wants to simply be sure that the things that he's given to staff are filtered through another set of eyes. In other words, I do think it's a serious allegation for anyone to say there's staff misconduct. I think our commissioner thinks the same thing.
Madam Chairman, let me try and simplify it. Mr. Walker, he's basically saying, I have 20 pieces of paper and documents that I want to give to TALCB. I want to make sure that all 20 pieces of paper go to the board and they're reviewed equally. Of the 20, I want to make sure that not only 19 go, but 20 go. And that's where the chair comes in to say, yes, I received all 20 pieces of paper, and it is complete, and therefore let's go ahead and go with the investigation or whatever we need to do. He just wants to make sure that somebody else has a set of eyes on that. And is that probably a simplified way of interpreting that?
Sure. I think the sole reason the commissioner sits with me on let's do something is so that we can do something. The position we've been in since February is uncomfortable. In my opinion, it's dangerous, and it creates problems for us, and so I'm simply trying to move the ball. So to facilitate some resolution or solution. So we've got a motion, and there is a second. And again, the floor is still open for discussion. Is there any additional discussion? If not, we'll have a roll call vote, starting with Mr. Barba. Nay.
Nay.
Mr. Padden, nay. Mr. De La Garza?
Yes.
Yes. Ms. Fontana?
Yes.
Mr. McAnally?
Yes.
Mr. Beard?
Yes.
Okay, so we do have a majority leaning towards the motion that was before the board, so the vote will be 4-2, and I am abstaining. Is that the correct count for the record? And we can move on. I will ask, I've been requested for a quick break, so let's give it 5 minutes, or actually, let's give it about 8, because it's difficult to get down the hall and back before then. It is 3:50 in the afternoon. I am moving us forward quickly because it is getting very late in the afternoon and several of us have to travel from long distances away. With regard to agenda item number 4 that we just left, there was a request for clarification, and that would be, Mr. Griffin, I'd ask that you provide the documents that you would like to get to me through General Counsel so that we continue to have a good chain of information.
Understood, and I've just done so. I've actually provided them to Mr. Oldham.
Okay, very fine.
And
Who then has provided them to General Counsel?
yes, they sit here right on the dais in front of me. Just to be clear, I am going to review these documents, and to the extent there is any information that I do not feel is appropriate, I will confer with the OAG's General Counsel before providing that to the chair.
That's fine.
Okay, I just wanted to make sure that that was on the record and that's what the plan was.
I suppose, again, just for transparency, I would simply ask that if you redact or remove something, that's simply not the content, but just the comment that, and I've removed 5 sheets of paper, page 1, 2, 7, and 9, would be the kind of communication we'd have.
Of course.
Okay, very good. We are on agenda item number 5, discussion and possible action regarding 22 Texas Admin Code 157.31 investigative conference. Hopefully, a fair amount of this was vetted as a part of the broad conversation that we've just had, but generally this deals with the comments or the questions that Mr. De La Garza was raising about what happened and why. Is there a staff member that's quickly prepared to just give us a quick overview and how it relates?
Yes, Madam Chair. As we discussed previously, Rule 157.31, Investigative Conference, is the title of that rule, was adopted by the board in August of 2013. It became effective September 11th, 2013. And under that rule, a respondent will be provided with the investigative report and a statement of investigative conference procedures and rights not later than 3 days prior to the date of the investigative conference. And it was my understanding, since I was not your general counsel at the time, that the board adopted this rule in order to preserve transparency and to provide respondents with some notice of what would be discussed at the investigative conference. And as a result of this rule, what happens is that when that document is provided to the respondent, that essentially triggers the availability of that document to any other member of the public that would file a request under the Public Information Act, Chapter 552 of the Government Code. And since that document has already been released, then there is no basis on which the agency can claim that it is exempt from public disclosure. There are There are other state agencies that have statutory exemptions for their investigative documents, and this is an item that we have on our list of statutory changes to present to the board later on to request whether or not it is this board's desire to pursue that type of legislative change in the upcoming 2015 legislative session.
Couple of just quick clarifications. Kristen, the first thing that you said is if we provide, we called it that document being the investigative report, is that the only thing that's subject to public release? Because I want to be sure the record's clear.
Essentially, the rulings that this agency has received from the Attorney General's office require us to release any document that is in our possession that has been previously released to the public.
Okay.
In other words, once it's released, it's available to everyone.
Okay, so this is the board rule, if you will, that opened a problem for us. And so there has been some conversation about how do we fix it. Obviously, Kristen's given us some background that we plan to make a statutory change, and so I would ask, is there anything we can do in the interim? Because I don't believe it was the intent of enforcement who made the recommendation or the board when it voted to make an entire investigative file open to the public until such time there was resolution to the issue.
Certainly, and there are a couple of different options that the board has available to it. One of those would be to amend this rule to not release the investigative report itself, but simply to release perhaps a list of discussion topics for the investigative conference, so that in that way the board preserves the transparency to the respondents, but you do not give up the privileged or confidential nature of the full investigative report. So that is certainly one option that the board could adopt.
And if the board wanted to do that, the process would be, obviously, we can't make that, I'm assuming we can't give you that direction today. Would it have to be vetted at a subcommittee level, or could we, if it was a board direction today, be prepared for the next future board meeting to actually take official action on something like that?
Yes, if that is the board's policy decision today, then we could bring that proposed amendment back to you at the next regularly scheduled board meeting.
Excuse me, Chris. You mentioned that there was a couple of ways of doing this. You mentioned one. What would be the second one?
Well, the first is the legislative change,
okay.
To pursue that legislative change. Secondarily would be to amend the rule to change what is provided to the respondent. And then alternatively, there's no requirement that respondents be provided the investigative report, but it is this board's will that they be given some information. So, whether it's a list of topics or some other list of information, it doesn't necessarily have to take that format as a list of topics to be discussed.
Other questions of staff? Action?
Madam Chair, I'd like to make a motion to go ahead and amend our present policy rule, excuse me, to only have discussion topics released to the respondents when they're going to be going into investigative hearings.
Conferences.
We have a motion. Is there a second?
Second.
We have a motion from Mr. De La Garza, a second from Mr. McAnally. Was that you, sir? Okay. I want to be sure that we're clear. Mr. De La Garza, is it your motion that be placed on our August agenda for action? That the proposed rule change be placed on our August agenda for action?
Unless we can do it sooner.
And again, that's exactly the reason I asked the question. The motion was styled as if we were going to make the change immediately, and if we can do so, I guess I'd ask General Counsel, is there a way to do so?
No, we have to post the proposed amendment in the Texas Register for public comment, and there's a 30-day public comment period, and then the rule would come back for adoption at the board's next meeting. So if the amendment were proposed in August, the amendment could be adopted in November.
Then, Madam Chair, if I can ask for further discussion and clarification of the topic in general, I wanted to make sure, especially since we have the privilege of having Ms. McClendon, who was on the Enforcement Committee at the time of developing this rule, will this amendment to the rule that we are recommending to the board satisfy what our intent was as an Enforcement Committee to allow the respondent to have information about what he was being accused of in the report? I mean, just...
No, I understand. I'm not sure that I'm qualified to answer the question. Are you asking that of staff or
like I said, since we have Ms. McClendon here, since we three were the people that wrote that rule, and our intent was, at the time that a respondent had been given notice of his informal conference back then, investigative conference, we did not want him to be so unprepared as to come to that informal conference with no idea of what he was being alleged wrong. That was our intent, was to give him access to this document so he would have some ability to know what the state saw as being deficient in his appraisal report. I'm asking if we put this amendment onto this rule for however many days it's going to take us to do it, was that satisfying the intent of this committee? And I would like to take the privilege of you, me, and Ms. McClendon being here today to make sure that we vet that out now, so if we get to another position of writing this rule or legislation correctly, that we do it with full intent of what we were aiming at.
Ms. McClendon?
Madam Chair, again, Shannon McClendon for the record. It may be more helpful, and I'm happy to work with staff, and you're exactly on point. You were there, Madam Chair, as well. What our intent was is to make sure that when an appraiser came in to one of these meetings, not all of them can afford lawyers, and they wanted to make sure they weren't bombarded or... Frankly, I sat through one and I was intimidated, and I was like in the back row along the back and that kind of thing, and I'm a lawyer, so I shouldn't have been. But anyway, I think I'm happy to get with the general counsel and anybody else who's necessary. I don't want to go through the process of necessarily having to do written comments because I don't know if I have time with that, but I understand what your charge is, and I don't know if it benefits everybody right now for us to try to flush that out. I'm happy to do, I'm at y'all's beck and call.
It probably circles full circle back to the initial question I asked, which is, does it have to be vetted at committee? And I would guess it doesn't have to be, except for the concern expressed, which might then make it appropriate to be vetted at committee level. Do you think that would be more productive? And do you have an intended enforcement committee meeting before the August meeting? Because my perception is I'd rather fix it quickly. Can we change the agenda to allow for conversation?
Actually, we don't need to change the agenda because the agenda has not been set yet. It will be set later this afternoon or in the morning and then posted. So yes, we can add that agenda item to the upcoming July the 18th meeting of Enforcement Committee.
Would that make you comfortable to have the opportunity to get input and be sure that the content that we're going to recommend?
Yes, ma'am. I'd also like to also say that also give us the privilege of having general counsel there to direct us on how we can do the legislative part also.
Okay. So it sounds to me that we've got consensus. Mr. De La Garza, was that your original motion?
We need to fix whatever there is, and if that's the proper way of doing it, well, or the more formal way, then let's do that. I mean, that's fine.
Again, that's what got the clarification is what got us here. Let me see if I can state what I believe the intent of the motion maker and the seconder is, and that is that this particular issue be sent to the Enforcement Committee for immediate vetting and placed on our full board agenda for potential action in August.
Sounds good.
Will there be enough days? Will the 30 days for the Texas Register and all that?
Well, you
Will happen after August.
Okay.
Right.
We have to make a
The
recommendation for it to go
enforcement committee will meet this coming Friday and consider the amendment, draft some proposed language to bring forward to the full board.
Perfect.
At the August board meeting.
Perfect.
We have a motion and second. Any further discussion? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. That takes us to agenda item number 6, discussion and possible action regarding process for handling public information request. Again, this is tagged to the conversations we've been having. Is there staff input or are there board questions?
What was the concern on this, Madam Chair?
I think initially it was included in your package so that because it is a part of what caused some questions associated with agenda item number 4. I suppose I do have a couple of quick questions, and so maybe that'll open the conversation just a little bit. So this is an open records policy and procedure dated, right? Is that the agenda item we're on? Yes. Because I'm guilty of trying to skip things over, skip over things. It's dated February the 1st, 2014, and I just had a couple of quick questions. It indicates to me that it was effective immediately, and so is this an update to a pre-existing policy, or is this a new policy?
It's an update.
Oh, excuse me, sorry. I guess I had it on already. It's an update to pre-existing policy. So we've had a written Public Information Act request, kind of policy and procedure. How do we handle it internally? And under our general counsels in the past, we have updated that. I think this would be the third update in the last 5 years. I think we did a fairly comprehensive and additional more training with staff. We added some additional safeguards in there and some consistency issues, and just to make sure we had. There's a distinction between a request that we honor as customer service. Somebody calls and says, "Hey, can I get a copy of whatever?" And it takes no time to respond. Those kinds of things. So we still do some things as a customer service response. That's all. However, with respect to complaints, we have now made it clear in this policy that all of those must go through the Public Information Act request documentation and deadlines process so that we have better tracking on all of that.
Commissioner, I'd just ask, this indicates that it was sent to TREC and TALCB staff. Was the update of the policy driven solely by staff, or did TREC or TALCB participate in this update? Boards. Did TREC or TALCB board members participate in this update?
No board members. This is all internal.
Okay. And was the board notified when the policy changed?
That it was changed in January. We did not notify you that it had been changed in February. I mean, at your February meeting.
Okay.
No. All of those, it is one of those on the list of general policies and procedures that the board has asked to review periodically. So.
Yeah. Is there a way for us to understand what got changed without, I don't want to read every line. This is a 5 or 6 page policy, but was it like global in nature? Was there a lot of change, or was there a single line added, or can we get
it was fairly focused, and I'll let our general counsel who led that effort address that question.
Okay,
now it is.
This policy in the form that you see it was comprehensively put together in this form in January of 2013. A few items that changed just came up, and really this is, I know it says policy and procedure, it's really the standard operating procedure for staff is what it is, so they know what to do and how to do it. A couple of things changed, and that just was to reiterate that an agency may respond to verbal requests under the Public Information Act, but that protections are not afforded, so that's on page 2, that last bullet in the first paragraph was added, that to ensure that public information requests are properly tracked and answered. I'm sorry, page 3. I skipped a page.
14 of 23 or 15 of 23?
Mine's not
Not numbered that way? Okay.
Okay. I marked the three places. So go to page 2, go to the very, very end. And this was something that was just questions that came up where we were getting, it's the part that talks about Social Security numbers.
Gotcha.
And so I was getting lots of requests as to what do we do, and our policy is we don't verify employment based on Social Security numbers. So that
I'm
was
just trying
that.
to put dots beside mine so you don't have to
Sure.
go into the whole
Sure.
thing, but I do need you to go slow enough I can dot it.
Okay, the next page,
So in the package at the board level, it's page 14 of 23 in the bottom right-hand corner. It's the very last bullet point.
Council would look up here, I think you'll.
Oh, thank you. But it's not marked like mine is. Okay, so that's what was changed there. The last paragraph about the Social Security numbers was changed. On page 5, that second bullet that starts although was added.
That's going to be page 17 of 23.
15 of 23.
Yeah.
I see one that starts with although on 15 of 23, although an agency may
Yes.
respond.
That was added.
Okay. We're with you.
Some of the personnel names may have changed as to who's in charge of doing what.
Okay.
And on the next page, I don't think anything changed on there. On the next page where that talks about cost estimates,
Yes, ma'am.
the last bullet,
About charges being waived.
charges being waived, that's always been there, but if you flip to the very next page, a note was added. It says at the very top, please note, even if there are no charges, a written request must be submitted by the requester and tracked under the PIA. That was a clarifying point.
Okay.
And I think those were all of the changes.
Okay. Thank you very much, Ms. Galvin. I appreciate the briefing. Are there any questions or comments from the board regarding
Chair.
this issue?
Just for the sake of clarification, Commissioner, you said this was an update from a previous standing order, from a previous policy?
Internal standard operating
Right.
procedure, yes.
Could you, maybe the next time something like this comes forward, just indicate what date we're updating it from? In other words, this was originally from January of 2013?
This is, the latest change was January 2013.
And then you did a February 1st update.
Okay?
In other words, show the previous, the next time this comes up, show that this was the.
The chain of modifications?
Yes.
The dates where those occurred?
Yes, as
Okay.
so we can have a track record as to see how often or.
Kind of like we do in the statutes?
Yes.
Yes, okay.
Just to have that. And it was very interesting, because Ms. Carey mentioned that this was an SOP. And it's the first time I hear that we have an SOP on anything. I'd like to see if we can implement an SOP for a lot of the things that we're doing. Actually, we need to have a standardized SOP.
Well, you may recall, Mr. De La Garza, that there was once a request, actually a Public Information Act request for all of our SOPs, and we actually did provide that, and it's included, this was included in that request, answering that request.
So we do have a standard operating procedure for everything that we do, and
We have many. I won't say that we have it for everything, for every possible thing, but we have many, yes.
so it's written.
Standard operating procedures.
It's written in a memo type form rather than a book.
Many of them are, not every one
This is a discussion for another time,
Sure.
Madam Chair, but just I think that we still need to develop an SOP.
I appreciate the comment, and it probably is appropriate discussion for other time. I appreciate the recognition of that. See, that's what's helpful when you've previously been chair, right? You begin to recognize that. So this is discussion and possible action regarding the process for handling public information requests. Is there action? Do you need action?
I don't think we need one.
Does staff need action of any kind? Okay. So the information has been received. We will move to agenda item number 7, discussion and possible action regarding the receipt of regular communication and briefings from the Commissioner about issues brought before the Board. This, too, I believe, has had a lot of conversation as it relates to our expectations or understandings of what is appropriate. Does the board have other concerns about regular communications and briefings from the Commissioner?
Madam Chair, and with you being your duties as a liaison on agenda item number 4, I really feel confident that probably agenda item 7 and 8, after we go through this process, we'll be able to line some of those things out a bit more clearly.
So you're saying maybe just move past agenda item number 7 to agenda item number 8? Is that the request?
Both of them, I think it would, unless there's another board member that has a question or something. I think that what your project you're about to embark on will help establish some of that in the future.
I'm certainly fine with moving past agenda item number 7. I have a couple of quick comments on agenda item number 8. Personally, I don't, and so hopefully that'll be fast if I'm the only one that does. So no action needed or necessary on agenda item number 7. The floor is open in case someone feels there is. Hearing none, we'll move to agenda item number 8, discussion and possible action regarding the performance and the duties of the Commissioner. The only thing I wanted clear to the board and the public is this. I wanted to inform the board that the style of this agenda item was directed by General Counsel. The desire of the board was to discuss, or the board members that were in communication, was to discuss the perception by the public of actions by the agency, specifically related to issues that we've discussed already today and others. But in preparation of the agenda, the board was directed we could not discuss personnel issues globally, but in fact must name someone in the conversation. After much debate and discussion, including the Commissioner and General Counsel, it was made, the decision was made to post agenda item number 8 the way it's posted. So I wanted to be clear that it wasn't an attempt to really go into a performance review, but simply had to be styled this way in case there were questions that weren't answered or dealt with by agenda item number 4. So I want to open the floor, because it's been asked, for questions or conversation amongst the board to lay framework, if any, for any other questions or comments that you have regarding issues associated with public perception of actions of the agency. Okay. Again, we've gone to a lot of expense and time and effort to get everybody here, so I don't want to close the door too soon. I also don't want to leave it standing open if we've satisfied all the requests. I think the only real question I have, or that has been presented, is I think it's an important conversation that we be on the same page as it relates to responsibility of the perception of the agency. I personally believe the perception of the agency responsibility falls to the board and to the Commissioner, and then as it relates to that, our staff. And so I guess I just ask, Commissioner, do you agree with that, or am I off base on that expectation?
Well, no, I absolutely agree that that I play a significant role in the public perception of this agency. I often go out and speak to appraiser groups and trade groups and work with them on the development of issues. Obviously have a large role in guiding or attempting to facilitate the strategic planning process through public hearings and those kinds of things. So I would absolutely agree with you that we share, and I may share a larger percentage, if you will, of the daily responsibility for helping to shape the perception of this agency. Absolutely.
And I think that's all we wanted, was the opportunity to have that open forum conversation to be sure that we weren't misunderstanding our role, or that I'll just leave it to me. I think the conversation's been had amongst others. Be sure that we're doing what we're supposed to do. So in our role of our job as it relates to the agency, when a board member receives information from the public, and if we believe it's our responsibility I believe it's our responsibility to share that information. To share that with you and help solve the problem. And when attempting to process the issue, sometimes it feels like, and again, let's just open the floor, that the board members feel like it's kind of removed from our hands. We're told, hey, we've got a problem, and we're told, hey, we'll take care of it. And so if we can open the dialogue to simply say, we want you to do your job, to take care of it. We want to participate in the resolution, and especially in the communication back to the individuals as it relates to solving the problem. So in other words, we don't want it to go into Neverland when we raise the concern at a staff level. I think we've been making forward progress on that. I think that's just a good thing for us to deal with. So the public perception issues that we've been working through, and again, I've been on the record several times in the last year of saying I think we're making good progress. But the perception still exists sometimes that we're heavy-handed, and that we have a tendency to be disrespectful, and that sometimes we stonewall change. I think at some points in time we've been asked to give examples, and I don't feel a need to give you specifics unless you want them. But I would just continue to encourage the resolution of those, we're still working through those, and be sure we're all on the same page that it's our job collectively to fix it.
Let me tell you that I hear that loud and clear, and let me re-encourage or just remind all board members that, my cell phone and my my regular phone are on the contact list for the board members, and please do not hesitate to use it. If you have if you become aware of something and you're concerned that it would have an outsized impact on the agency, please bring it to my attention. And absolutely, I really do encourage that open communication.
Madam Chair, if I may take the privilege of taking the commissioner up on public record as to his offerings. And I will say, Mr. Commissioner, you have, at every moment that I have asked for you to hear, you have heard. And there's been several instances in which not only you have heard, but you have, I have given you suggestions and or comments, and you have let me know that you heard them and would take action on them. Just for public benefit and for a point of reference, I have been serving as a committee member of our enforcement subcommittee for the last 3 years, and I currently chair that subcommittee. So please understand that the focus of my comments are on enforcement, but globally, they are concerning the management of this mindset and that division. So the samples that I have are enforcement related. To begin with, complaints that are being processed, they have no significant evidence or proceed are processed anyway. So the complaints that I'm hearing out on the street, or the things that are being brought to us as enforcement staff, enforcement committee members, and that I've addressed with you, have some pretty weighty allegations to them. You have asked me on several occasions to bring you evidence of those allegations, and I have, to the extent that I have that evidence. But I'd like to just refresh and not be on the record of some specifics. We asked, in an enforcement committee, we asked the commissioner and the director, Mr. Marnack, if at any point did we ever accept a complaint with no signature. This complaint form, I assume, that is designed to prevent an anonymous complaint.
That's correct.
Without that signature or certification of the truth, it doesn't exist. Would that be correct. I'm sorry, let me just go ahead and finish, and
Sure.
you can travel with me here. At a minimum, our standard should be to require a signature. Another example would be,
Let me just ask a question. Do we require a signature on a complaint?
Yes, we do, and that's in the board's rules.
okay, thank you. Another thing is that I asked the question, have we ever processed or proceeded with a complaint that had to do with the appraisal fee? And there's an allegation out there that there was, and I have evidence of that allegation with me. Also, no complaint. At some point, we said that we do not entertain any complaints about market value. In fact, at some point in the past, our form had a disclaimer at the very top of our complaint intake form that stated that we would not consider a complaint if it had, if it was being submitted based on value. And as I was looking through our documents now, that has been removed. It is no longer on that complaint form. Just the last one. Go ahead.
So again, just a question. So is that a change in process? Do we now accept complaints that are solely driven by value, or was that removed for some reason? I mean, I realize I voted on the removal, so I'm just asking, again, more for clarity for the record.
Well, and I'd like to know, I would have never voted for that removal. I would like to know when we voted for it. I see where the form changed, but the form, from the information I have, the investigation I did, the form changed and it was omitted whenever we added the AMC, when we combined AMC and appraiser complaint together. And then all of a sudden on that form, that statement's no longer there. And I'm sure I know I voted to pass that form. I just did not know that that omission had taken place on that form, and it was my responsibility, I'm sure, to look over that.
So did it change the way we operated, I guess, is my question.
It does not change the way we operate. It was removed when the complaint form was changed to include AMCs. But it does not change the way we operate. And let me just make sure that it's clear. Many complaints are complaints about value. Okay, the ones that we give no credence to are the ones that only assert they got the value wrong. That's the complaint. The entirety of the complaint is they got the value wrong. We don't consider those because that's a professional judgment. Now, if they send the report and they circle several items on it and say got it wrong here, 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 and here, well, now we have something to deal with, even though the allegation is that the value was wrong. But if the complaint merely is, and we have more than our fair share of disgruntled homeowners or people who didn't get their refinance or whatever, and they simply say, the appraiser was rude, unprofessional, and they got the value wrong. We don't typically open those complaints.
I understand that. I can back you up in the fact that being on enforcement committee this long, we have many more complaints that we dismiss based on that particular fact than we don't. I'm talking about perception. I'm talking about things that are out there in our industry, and people are saying, whoa, I didn't think you did this, and their perception is that the only thing about their complaint was value driven. So my fourth and last one would be, has been stated by staff that we do not process or proceed with a complaint that has no report to investigate. So I guess that sort of begs the question, what are we investigating? Why? And just to let you know that the perception out there in the industry is that this is why some people are thinking that through these staff-initiated complaints that we are creating work for ourselves. I'm just bringing these perceptions to you so you as the commissioner can help us to make sure that we are not sending a perception that we do not intend to send to the public.
I'm certainly fine if you've got answers to those. I do understand that Ms. Fontana's brought those to you individually already before, so you may have answers to them. Do you wish to answer them?
Well, I was just going to deal with them in general. So we do not process complaints without a signature. Now, if someone sent us a complaint, they send the complaint to us and they identify themselves, but they merely forgot to sign it, we'll send it back and say, you need to sign it. I mean, they're not trying to file an anonymous complaint, they just forgot to sign it. So we do have some of those issues occasionally, but we don't process anonymous complaints. True. Regarding the payment of a fee, it depends on what the allegation is. Again, we do have complaints occasionally that the appraiser, charged this amount of fee and agreed to do this amount of work, and they didn't do that amount of work. Okay, well, that's different than it's just a fee dispute. So there's some ethical requirements there, and we may investigate that. But as a matter, if somebody just sent us a mere report that said, appraiser charged me too much, we're not going to investigate that. Okay? Mere value I talked about already. Without a report, I guess is the other proceed without a report. Sometimes we do open a complaint because of the seriousness of the allegations and seek to get a copy of the report. We obviously, and have had this happen several times in the past where in the end, there's nothing for us to investigate because the report no longer exists. It wasn't provided to us. Yes, there were serious allegations. We've attempted to find a report. There is no report. Dismiss the allegations. So we do have that. So it's not completely accurate to say we can't proceed if we don't have a report. It depends on the nature of the allegations, but we always attempt to get the report.
All right, and again, just to reinstate, these are things that I have brought to your attention before, and they are to clarify public perception of the fact that it appears to some people that we are doing things that we say we do not do. So thank you.
I think we're nearing the end. The only other comment that I would make, and again, this is because we're all together and the purpose of this meeting is to get it all out on the table, is the comments that there are concerns about us being disrespectful. And I think we have addressed those, I believe, with you and in one-on-one situations, Commissioner, and I will say that we've had some even responses in a public setting that are concerning to me. I would only ask that at a minimum, if someone's willing to stand before us and be respectful in their presentation, that we find a way to give them our full respect back. That doesn't mean we have to accept everything they say, but if we receive accusations at the public microphone, my preference, and it's only me, but my preference would be that we receive that information, thank someone for giving us the information, do the investigation, as we've indicated that's the appropriate thing to do, and then respond to such without defending the comment in a way that might come off as being bullying. So I would ask that we just continue to work towards that, if that is your desire. Certainly it's your staff, but we are responsible for expressing those things that are concerns to you. So I would simply ask that we receive some assurance that somebody's addressing the things that we bring to you and that somehow we get feedback that something's actually been handled. For instance, if there's an accusation against staff or a process that we are doing, that at some point in time we actually find out what your end investigative results were, that there was no validity to the complaint, or that there was something and you've handled it. I don't need the details for how you handled it in particular, but simply that it's been handled so they're not left just standing out there, which has been something that we've done in the past. So people will make a comment into the public mic. There's never a comment back in a public setting, and the board never really gets good indication of what the final resolution was.
Thank you for that, Madam Chair, and I take that direction very seriously to make sure that, in fact, we record those requests, address them, and close out. And as I'm sure you are aware, the board is aware, we actually have staff now. We debrief every meeting, after every meeting, and then we check to make sure that everything that was heard, so lots of different people take notes, and then we sit down and put it all in one giant list that says, okay, here's all the things that were requested, here's who it's assigned to, and here's when it's supposed to be done by. So.
And I appreciate the efficiency of that. I don't think that did exist in the past, and it certainly helps me. I know we came away from a meeting at one point in time where I think I had 20 to-do items on my subcommittee list, and in fact, I reached out as I left this meeting to each of the other subcommittee members and asked them to assemble the information for me. I was very relieved when I reached out to the commissioner to then say, I think I've got the list, when he said, in fact, we've re-listened to the tape and created one. I found that to be very helpful. So I commend you for that and appreciate the efficiency that it does create. Are there other questions or comments as it relates to agenda item number 8?
Madam Chair, I would like to, and for the sake of time, Mr. Commissioner, I would like the board first to know that I have addressed several issues directly with the Commissioner one-on-one, specifically in a meeting June the 4th. At that meeting, the Commissioner was receiving all of the information firsthand that I'd hoped to hear some direct follow-up on me asking the Commissioner to take care of some of these allegations that have been made. And first of all, I'm not going to go over all those 3, but I'm sure that you know what they are, and I would like the board to know that I did make a suggestion of you. If these the allegations I'm referring to were disrespectful responses or comments to the public that were happening in investigative conferences. So my suggestion to the Commissioner was that he could possibly audio tape these investigative conferences so we could make sure that these allegations were in fact not true. You have to understand, these appraisers, they feel like they're under this microscope and they feel very defensive and very threatened, and you can imagine that their little word that the investigator said could turn into this huge story. I get that. But we were getting too many allegations of some pretty disrespectful things, disrespectful comments from our investigators to our respondents, our appraisers. So I guess my question to you, Mr. Commissioner, is, and by the way, I did let you know that I had asked our general counsel what she thought about that process, and she did agree that she did not see that there was anything that would keep us from doing that legally. So have you had the chance to, first of all, look at those 3 allegations and have anything to report back to me, and what have you done with my suggestion of audio taping?
Okay. Madam Chair, I've got to leave, so I'm just going to excuse myself, okay?
The board will dismiss Mr. Beard. He has a plane to catch. Thank you, sir. It is now, and for the record, it's 4:40? 4:37. Thank you. Safe travels.
So, Ms. Fontana, I just want to make sure that, because I know in that conversation, I let you know that, in fact, staff had actually made that suggestion themselves much earlier when we had an earlier raft of those kinds of allegations that, staff they're being bullying and all that. And they said, well, why don't we just tape it? And at that particular time, we went through, I'm not sure if it came to the Enforcement Committee or not, but I do believe this is an appropriate thing to come to the Enforcement Committee. We do need to fully vet the whole records retention kind of issue and purpose, and You know, is this going to be, are those audio tapes now going to be subpoenaed for rebuttal evidence at SOA hearings, and, you know, all of those kinds of things that I think need a full vetting. In theory, I have zero problem with accountability that way. I really do think that that's it's one of those things that we do not currently have the ability to do all calls through our phone system. That was one of the other potential suggestions, because sometimes that's an allegation that during a phone call. But certainly
I really don't mean to interrupt you, but respectfully, because of time, that's no more added information than on June the 4th. So in the future, if you have any direction that or suggestions that you'd like the enforcement committee to take that up, I'd be glad to. I'll work with GC to figure that stuff out. I just wanted to know if you had any additional information that you wanted to give me today based on the questions and the suggestion that I made to you. So to just keep things moving, I'm satisfied with not yet, or we still need some things to talk about.
And Madam Chair, just to be clear, yes, I did say as the General Counsel that there is no legal impediment to recording these conferences. However, doing so could create similar issues that we have asked the Enforcement Committee to address in possibly amending the rule where we disclose the investigative report to members of the or to respondents and members of the public. So, of course, that is something the Enforcement Committee should vet fully before proceeding down those lines.
Sounds like that's a fortunate turn of events since Ms. Fontana chairs the Enforcement Committee. You think you can make that happen?
I sure expect I'll try.
Okay. You can get it on the agenda at a very minimum for your subcommittee to work on.
And if there are any other, and I apologize, Ms. Fontana, not being prepared to discuss in this open meeting what we discussed in a private meeting, but I am happy to give you individual follow-up on each of those private allegations that you brought to me. And I don't mean that private. It's not private. It's open record kind of stuff. But I wasn't prepared to deal with that here today, and I apologize.
No problem. Thank you.
Other questions, concerns, comments? I don't see any action needed. Does anyone from the board feel any actions needed? Hearing none, that we will move to agenda item number 9, which is executive session. Is there a need for executive session? Is there a request for executive session? Hearing none, we're on a roll now. I can move to agenda item number 10, request for potential future meeting agenda items. The only one I believe coming from this meeting is the rule regarding agenda item number 5 that I think we've made clear on the record that enforcement's going to take up as soon as Friday, and we'll attempt to provide some recommendation to the full board meeting in August. Are there other requests of the board for future agenda items? Hearing none, that takes us to agenda item number 11, discussion and possible action to schedule future meeting dates.
And there is a regularly scheduled quarterly board meeting on Friday, August the 15th is the next one on the agenda. The next regularly scheduled meeting.
And I certainly think our goal will be to have no additional meetings between now and August the 18th, other than the called 15th, other than the called subcommittee meetings. It takes us to agenda item number 12. If there is no other action for this board, I will consider us adjourned at 4:43.